with their electronic devices. There's no apologies. The draft minutes, hopefully members have had a chance to look at them. If you're content that they're accurate, then they will sign them accordingly. Agreed. And some matters arising was the updated forward work programme, and it's there February to March, pages 73 to 79. And as we agreed last week, the Attorney General is coming to the committee on the 6th of March to provide advice on the Human Trafficking Bill and the oral briefing by the Prison Governors Association on the Prison Reform Programme, and that's been brought forward and will now take place on the 27th of March. Also, there's been some correspondence from Ugly Mugs, i.e. in respect to the issues that we've been looking at, and that's available for members. There's responses also from the Office of the Lord Chief Justice and NIJAC regarding the judicial appointments process and the High Court judge competition. The Office of the Lord Chief Justice and the Interim Chief Executive of NIJAC have responded to the recent correspondence from the committee regarding the attendance of the Lord Chief Justice and Lord Justice Coughlan on the judicial appointments process and the High Court judge competition, and our request for additional papers. These responses and previous correspondence are at pages 3 to 14 of the tabled pack. The Lord Chief Justice's office, having taken legal advice, is of the view that the committee has no jurisdiction in respect of the High Court judge competition. While the Lord Chief Justice is content to meet with the committee to talk about the judicial appointments policy in general, he does not consider that the committee's policy interest carries with it the power to scrutinise the High Court judge appointment, and has asked the committee to reconsider its position. NIJAC has indicated that the papers requested constitute confidential information, and disclosure to the committee would not be lawful under Section 9I of the Justice Act 2002. So I'm not sure if members have had a chance to look at the correspondence in the table pack. Pages 3 and 4. Obviously, the letter highlights that the Lord Chief Justice, having repeatedly asked this committee to reveal our legal advice as to whether or not we have jurisdiction to pursue this particular issue in the context of reviewing the workings of NIJAC. We obviously didn't do that, which is normal practice. The Lord Chief Justice has now taken his own legal advice, and he has summarised it for members' benefit. And then in the concluding paragraph, the Lord Chief Justice hopes that the committee will reconsider its position in light of this letter, but if the committee resolves that it should continue to act outside its powers, he wishes to make it clear that neither he nor Lord Justice Coughlan could lend themselves to such unconstitutional conduct.
My God.
So, members, obviously it's for the committee to consider how we wish to proceed. I was somewhat taken aback by the correspondence from the Lord Chief Justice, and the tone of the letter I don't believe is helpful. It's not conducive to the type of relationship that we've been seeking to build with the Lord Chief Justice, and I do feel it's an attempt to frustrate the workings of this committee. And we have a constitutional responsibility to scrutinise the working of NIJAC. It's a public appointments body, therefore it should be subject to public accountability, and we're democratically mandated on behalf of the people of Northern Ireland to carry out this job. But Sir Declan Morgan is obviously taking a contrary opinion to this on points of legal technicalities. Obviously, in the first instance, I think we should refer this to our own legal advisors for them to provide advice to this committee upon. But I am disappointed at the approach that's being taken. To me, there were matters of extreme public interest that Des Marinan brought to the attention of this committee. It would help us in terms of the review that we're going to take forward into how NIJAC operates, which other people have said is ultimately judges appointing judges. They have assumed a large amount of powers, and indeed this Lord Chief Justice has said that the Human Rights Act invites the judiciary to intervene on a lot more issues than what used to be the case. I take a contrary view that we're democratically elected to legislate and judges operate within that framework. But given that judges need to be whiter than white and their appointment needs to be beyond reproach, well, I think we have a role and indeed a responsibility to scrutinise a process that puts into place individuals that are incredibly powerful within our society. So that's my view, members. I think we should be continuing to pursue this matter, and I'm open for other suggestions if committee members want to make any further comment. Mr. McCartney.
Well, only getting a letter today, I think we should be seeking legal advice, because it nearly implies that any appointment pre-devolution we have no role in. Now, where's that beginning or end? If someone come to this committee and said that perhaps the appointment in our public body wasn't done by due process, does that mean that all previous appointments pre-devolution are someone else's responsibility? I don't think so, but we need to get legal advice on it.
Any other members have any further comments?
Chair, is this letter suggesting that up to the present we are acting outside our powers, like what we have done up to the present? If you read that, it says resolves that the committee should continue to act outside its powers. That to me tells us that they're suggesting that we have been acting outside our powers. I think the legal advice we need to get this like that to see where we as a committee sit on.
I think the letter certainly has a chilling effect.
Yeah.
Sure,
Mr. Dixon.
the Lord Chief Justice has shared his legal opinion with us. You've suggested that we should refer his comment, and lawyers, I'm sure, will either agree or disagree with one another. But it may very well be more appropriate, rather than sort of I know what I know and you know what you know, and we're not sharing the information. The Lord Chief Justice has shared his point of view with us. I think we probably need to get our own internal assembly legal advice, and probably waive our right to hold that to ourselves, so that we can directly share that with him, so that the two legal minds can express their views frankly and openly with one another. I think as a lay member, while I understand the principles of openness and the appropriateness of public appointments, I nevertheless think if there are conflicting legal views, it's best that those parties share that information with one another, so at least we can see the wood for the trees.
Sure. Thank you very much, Chair. Very disappointing letter, and I must say I had hoped for more, particularly given the earlier correspondence to this committee in the aftermath of Judge Marnan giving evidence to this committee. So there does seem to be a change in attitude, because what could have been said then was what's being said now. But nonetheless, we have got to take our own legal advice and see how we deal with this correspondence and what is the proper and correct way forward. But it is disappointing, given the fact that serious issues were raised in front of this committee, and if we accept what we said in this letter, we simply say, well, there were serious issues, but there's nothing we can do about it. And I think that would be a very bad situation for this committee to find itself. Thank you very much, Chair.
Yeah, and the U-turn in respect of the approach that's now being taken by the Lord Chief Justice is manifest. That on the 24th of October, he corresponded with this committee. This is before Judge Marnan gave evidence to the committee, saying that I understand the Justice Committee will now be meeting with the judge on 7th of November. The Chief Justice has asked if the committee would also be available to meet with him on either the 14th or the 21st of November. Yeah. So there seemed to be a particular interest on the part of the Lord Chief Justice to be here to respond to whatever Judge Marnan said. Having heard the evidence of Judge Marnan, now there are obstacles being put in the way of this committee. So I'm disappointed as well, Mr. McGuinness. I share your sentiments in respect of that. Mr. Wells?
Mr. Chairman, yes, I've detected that as well, and I mean, I think we may have hit a raw nerve here in this investigation. something in the evidence clearly has annoyed the Lord Chief Justice, and he's unhappy with the direction which you're going. I take great exception to the comment that Mr. Anderson mentioned. He says, should the committee continue to act outside its powers? I don't believe we've been acting outside anybody's powers up to this point. I believe we've had very clear direction from our legal people. And if this comes to an impasse, we're going to have to consider, if our legal advice still continues to tell us that we're doing the right thing, it's entirely legal, then we're ultimately going to have to consider, do we use our powers to compel the Lord Chief Justice to come before this committee? Now, I hope we never get to that point. I think we should do these things by agreement. But certainly, we clearly are pushing on something here which is not going down well, and now that makes me even more determined to get to the bottom of this appointment.
Well, I don't think the Assembly has ever had to use the legal powers we have to compel someone. It would be pretty unprecedented if the first time we do that is someone the Lord Chief Justice. And if there's a dispute, if there happened to be a legal dispute about that, we would end up in court, and a judge would have to determine if the Lord Chief Justice should come to this committee.
Will we get a fair hearing?
Would we get a fair hearing? Well, we could ask Judge Marinan.
To hear a case.
Maybe he could hear the case for us. Well, all joking aside, that is a point worth noting, but I think we should refer this to our legal team to get advice. I am disappointed in the response. I've obviously made that clear, and other members have made that clear, and I think the committee is unhappy that we're not getting the cooperation that we anticipated to receive. So let us take our own legal advice and determine how we should continue to pursue this matter. But I think people are mistaken if they believe that this committee will drop the ball on this issue. I think we're intent on pursuing this, and people would be better cooperating with us as opposed to trying to persuade us. Okay, members, we'll move on. The next item is the evidence session from the Police Service of Northern Ireland, so if officials want to come forward. For members' benefit, the bill and the explanatory memorandum can be found at tab 1 of the bill folder, and a copy of the written submission from the Police Service is at pages 99 to 107 of your meeting folder. So let me officially welcome Assistant Chief Constable Drew Harris and Detective Chief Superintendent Roy McComb to the meeting. You are both very welcome to the committee. I appreciate you taking the time to come and speak to us. As with all of the evidence sessions that we've held on this subject, it'll be recorded by Hansard and then it'll be published for the record in due course. So I think I'm going to initially invite Drew to make some comments to the committee, and then members will have some questions.
Thank you. My name is Assistant Chief Constable Drew Harris, and I'm responsible for Crime Operations Department within the Police Service. That includes Organised Crime Branch, of which Detective Chief Superintendent Roy McComb is the head. I'm also responsible for serious crime investigation, intelligence and surveillance, and I've been in that post for 5 years. But just let Roy introduce himself then.
Thank you, Chair. Thank you, Mr. Harris. Roy McComb, I'm Detective Chief Superintendent, Head of Organised Crime, and I have responsibilities for organised crime led by the Police Service across all of Northern Ireland, which includes human trafficking, prostitution, drugs investigations, extortions, armed robbery, and a range of other criminality.
Okay, well, thank you very much for the invitation to give evidence. And we do very much welcome, as a police service, the opportunity to contribute. And firstly, we would highlight that the benefit there has been from the debate that there has been in public around creating a publicity and creating important public knowledge, so that there's an understanding in the wider community of the type of crimes that are going on in Northern Ireland, primarily what is happening in respect of human trafficking and how people are being exploited, not just in terms of prostitution, but in terms of forced labour and domestic servitude. But also then to increase public knowledge on what they might do to assist us in detecting these offences. Secondly, I would highlight that the police service's focus is on serious harm, combating human trafficking for whatever purpose it might be, and I've already highlighted those, and also then combating serious harm from organised crime groups who are involved in prostitution. We welcome the focus that is on victims and protecting the vulnerable, whether they have been trafficked or not. And would highlight that individuals caught in this web are on a continuum of vulnerability, all of them, and that continuum is one of grave danger through, I think, to vulnerability of assault or serious sex assault for all those who might operate as a prostitute. And one only has to look at 2 instances of murder of prostitutes, particularly in Great Britain, to see the dangers which are inherent. In respect of Clause 6, which has received a lot of attention, and I want to just say a few comments in respect of that. Firstly, we think it sends out a strong message, but we recognise in the first place that it's for the Assembly to pass legislation, but we do believe it does send out a strong message, and the message we think should be one of that Northern Ireland should be seen to be a difficult place for organised crime groups to operate. And in part, the attention and focus on human trafficking and then the prevention of prostitution are important messages within this. We would envisage that if the law was passed, prosecutions may then flow, but these would flow from, we believe, major investigations which are ongoing into organised crime groups, and they would in effect be prosecutions as an additional adjunct or benefit to organised crime group investigations into either human trafficking combined with prostitution. But it should be recognised that the character of prostitution in Northern Ireland is not unique, but it does have certain characteristics. It is mostly born through the internet and through website adverts. Secondly, it is off street in the vast majority of cases. There is some on street, but very limited. It therefore is clandestine, and individuals who seek prostitutes do run the risk of public shame, and therefore may be classed as risk takers in this particular society because of they may be ostracised from their friends and their families if it became aware that they used prostitutes. So therefore it's difficult to assess how much impact the threat of prosecution would have on this particular behaviour. But we ourselves, we concentrate upon the organised crime groups. We continue to do that, particularly in respect of human trafficking and then prostitution. And the other aspects, wider aspects, say in respect of Northern Ireland as a target of organised crime groups, is that Northern Ireland is seen in a global stage as being an affluent place. We will be continued to be targeted by OCGs, and whether the legislation is passed or not. A demand now exists for prostitutes and prostitution within our society and on the island of Ireland as a whole. Crime gangs do regard it as being high yield in terms of cash and hard cash that it does yield, and also seen as being low risk, and therefore then it is attractive to organised crime groups to get involved in this particular crime. We in the PSNI remain committed to preventing serious harm, tackling organised crime, and if the Assembly passes legislation, to use it to the best effect as we can. Anything you want to add, Roy?
Okay. Thank you both very much, and members will have some questions. Let me get straight to the issue around Clause 6. And I'm noting the comment that you've said it sends out a strong message, and that you would be linking this clause within the legislation to tackling serious organised crime. Should we pass this bill including Clause 6, how would that complement the tools that legislatively currently already available to the police to tackle serious organised crime?
Well, it's an additional offence for which prosecutions could be mounted, and you've already received evidence in respect of of the lack of prosecutions there's been in respect of those individuals who have used prostitutes who have been trafficked. And those have been defeated by being statute barred. I know the legislation will change to accommodate that, but it offers us another plank on which to mount prosecutions against those who have used prostitutes. But the evidential opportunities in this are limited, and it would therefore be part of a larger investigation involving surveillance, involving all the tools that we bring to bear against an organised crime gang that would probably best placed to facilitate such a prosecution. We would need really probably a wide scope of investigative effort and using a lot of the investigative tactics to gain the necessary evidence. And I won't go into all the detail of that, but it would require large-scale effort on our part. But that happens anyway in case of organised crime groups. We do put a lot of effort and a lot of resources into these investigations, and I would say prosecutions from that may flow.
Can you give me a sense of the nature of the crime gangs that are involved in prostitution, and are they involved in other criminal activities?
The assessment around organised crime generally in Northern Ireland is led by the police but supported by other law enforcement agencies through the auspices of the Organised Crime Task Force. We estimate that the numbers of organised crime groups in Northern Ireland fluctuates, but at the moment is sitting at around 145. That's 145 individual groups that could be made up of 2, 3, 4, up to 10, 12 members at a time. So the better part of maybe 1,000 people could be involved in organised crime as almost a day job in effect. In respect of human trafficking or human exploitation, which embraces the human trafficking for matters other than sexual exploitation, as well as prostitution, because there can be prostitution that isn't human trafficking, it can be organised crime through prostitution. For the most part, what we're seeing at the moment is that activity being carried out by the non-Indigenous organised crime groups, groups that are from outside Northern Ireland. That has changed slightly in that for a period of time the non-Indigenous groups were working with Northern Irish crime groups. That has evolved into a position where the greater number of the crime groups involved in this activity would be from outside this jurisdiction. And we have led a number of investigations that have had not only across Europe but a global reach because of the nature of the internationalisation of organised crime in this country.
In terms of Clause 6, and I just want to be clear on it, you're not opposed to Clause 6? The PSNI has no opposition to Clause 6?
We have no opposition. I can say overall in respect of the bill, we do welcome the bill, we do welcome the focus on victims, we do welcome the focus on what other legislative tools may be brought to bear around human trafficking and then also prostitution. But our focus would be around organised crime groups. In respect of Clause 6, no, we have no opposition. I think there is a qualification in our mind about its impact going forward, because what are the unintended consequences? Outside of the organised crime group element of prostitution, we do have links in with the remainder of the industry. We do wish to provide them a service because they are vulnerable, wish to make sure they are protected. And in passing this legislation, we want to be careful to maintain that sense that those individuals do feel the police service will protect them from assault, serious harm from crime. And some of that has been highlighted to us in correspondence from Ugly Mugs as well. And we would just, we have a qualification in our mind around what the overall impact, the unintended consequences might be. But as Roy has stated, most of these groups who are operating prostitution into the island of Ireland, including Northern Ireland, are coming from outside the jurisdiction. And this in itself, the legislation, the proposals, may in some way act as a strong message, not sure how much of a deterrent, but at least a strong message of the intent of the Assembly and of wider society and our revulsion of this type of crime. And again, we don't know what the consequence, the benefits of that would be, but
But you
it's
do
not, it'd be too wrong. It would be wrong to say we're opposed. Just there's a qualification in our own mind about the service. Then, our relationship and our contact into the rest of those who are prostitutes.
because there have been some in the media, those who have sat in front of us saying we're on the same side as the police service of Northern Ireland. They don't want this bill, and neither do we. Where you see the particular benefit is as an additional tool to tackle the serious organised crime gangs. That's, I'm taking it where you're saying
Yes.
this will be of benefit to the police,
Yes.
giving another tool.
I think, of course, there's investigations in respect of just public nuisance element of prostitution, but that is balanced as well in that we do not want victims of serious crime, any victims of serious crime, but particularly those who are vulnerable, not feeling that they can come forward to police and make complaints. And prostitutes are particularly vulnerable in society and vulnerable to very serious crime and assault. We want to make sure that they feel they can have a relationship then with the police, one of being able to make contact with the police and report crimes.
Well, I certainly welcome the police's position on Clause 6. In terms of, you touched on how you then support victims of human trafficking, and we met actually in an informal meeting just before this one with a girl who gave us her real name, but the name that she preferred that we would use in public was Anna, and I think she's familiar to the police because there was a case recently that led to a prosecution in Sweden that you were organised in, and she provided us with her documentation to say, I am a victim. SOCAS gave me official certificate that I was a victim of human trafficking. So we met with her. One of the comments that she made, which was alarming to me, was how she felt police didn't necessarily treat her as a victim, but more as a source of information to get a prosecution. And she did raise questions, which I think the committee will want to look at. How do we support victims, not just from a police point of view, but as a broader welfare type package? How can we support victims? But she did indicate that she felt the relationship between herself and yourselves as a corporate body was more, she's a source of information to give us intelligence about the people involved and potentially get a prosecution, and she didn't necessarily feel that she was being treated as a victim and the needs that she had as a victim being taken care of.
The first thing to say is it would be very difficult for us to comment on an instant case. We need to respect the circumstances of an individual. I'm alive to the individual you're referring to, and we've had significant involvement. On a broader point, the entire approach that we take in respect of human trafficking is victim-centric, and we have made it known to all of our staff and to the investigators that we would rather have an investigation fail than lose sight of the rescue and recovery of a victim. So that's the first thing that we do, that's the first thing that we seek. If we can manage to do that and to then frustrate, disrupt or dismantle an organised crime group, or to detain or detect people involved in the trafficking of people, then that's a secondary bonus. But the first and only thing that we're interested in is the rescuing of the victims. Now, the provisions of services to support victims of human trafficking are well established. They're not provided by the police, but the first contact as first responders by the police is obviously very, very important. Clearly, when we go into an environment where we think we're rescuing victims of trafficking, we're still trying to catch up on the curve of knowledge. So we do have to speak to people and gather a level of information from them. And it would be churlish to suggest that they're not sources of rich information, and it would be foolish of us to not pursue that as well. But our opening line and our starting position and our consistent position is about rescuing those people and making sure they do get the level of support that they require through other agencies.
And I would expect that response. And I suppose my next question is, how do you ensure a consistency of that type of approach amongst all of the officers involved?
Well, in one sense, the investigations that we've done have been done by a small number of my investigative teams who have developed over time a high level of specialist knowledge around this type. We have provided training to the greater number of members of my branch. They have been exposed to national level training. You know, we give them all of the training. We give them exposure to these operations, these investigations, and because we are the branch that leads on these investigations, it's not being dealt with at the broader police family. Therefore, there's a consistency of approach because it is being dealt. These are being dealt with by a relatively small cadre of officers within organised crime branch.
Okay, thank you. Mr. McGuinness.
Thank you very much, Chair, and thank you for coming. It's very useful, and your written submission also very interesting. I'm trying to understand the nature of the problem here in Northern Ireland. Yes, there is some prostitution arises out of human trafficking, but there is also what I might term indigenous prostitution. Maybe that's the wrong term, but you can correct me if I'm wrong. Which is different and is separate from human trafficking.
Yes.
What's if I'm right in that distinction, what's your assessment of human trafficking in terms of providing people for prostitution?
The scenario of human trafficking provides one part of those that are involved in prostitution. The greater number of people that are involved in prostitution in Northern Ireland are not the victims of human trafficking.
Yes.
And probably the greater number of people that are involved are also not indigenous to Northern Ireland.
Yes.
So we have experience of seeing people from the wider part of the United Kingdom, from Ireland, who do travel to Northern Ireland because, as Mr. Harris has said, there is a market. There is a market to be serviced, if I may use that expression. But the greater number of people that are involved in prostitution here are not the victims of trafficking. But trafficking does provide a rich source of personnel that are being put into brothels. Part of that, I think, is to meet almost the personal choice that the most part men that are using brothels are expressing. You know, they almost like the idea of somebody who is not from Northern Ireland.
Can I take it then that prostitution, or an element, or some section of prostitution, is very mobile insofar as there are people being shipped around the country,
There's an
Britain, and so forth?
There's an expression called the chicken run,
Yeah.
which is an expression used in the trafficking industry, where girls would be moved from locations throughout not only the Northern Ireland but throughout the island of Ireland. And there's been documentaries about that to show that there have been people moved around. And part of that is simply to meet the choice of people who want to use the services, rather than revisit a brothel, you know, a week later and find the same girls there. It's to keep that sort of
and
market fresh, as it were.
And it's much easier to move people around.
And the second element is that, especially in the area of people that have been trafficked, the majority of the girls that we have rescued have not a clue where they are.
Yeah.
They rarely know which country that they're in, regardless of, even though the language is clearly English, but they don't know which country they're in, and sometimes they certainly don't know which city they're in.
Now, just in terms the sort of trafficking of girls for prostitution, has that got bigger over the past number of years? I presume it has.
Well, I think we would say that it's a well-established crime activity now.
Yeah.
And we've seen that develop from the last number of years, from our understanding of quite small, from Operation Pentameter in 2007, 2008, and it has developed to the point where we have appointed a senior officer to lead on it, because we recognise it as a growing threat.
A growing area, yeah.
Yes.
Just in relation to human trafficking for labour, for servitude.
Yep.
How big is that in your estimation?
I think that's probably the next challenge for us, in that there is we have been very much focused on the sexual exploitation end of the human trafficking
Yes.
chain. But I think there's probably another area of business that we would have to look at in respect of the labour exploitation. And in that respect, we work with other agencies such as the Home Office Immigration, who are involved in the immigration offences.
Now, we've been grappling with this for quite some time, trying to get an understanding of the whole situation. There's an argument put forward, look, forget about Clause 6 aspect, forget about that, because really the situation in Northern Ireland is such that human trafficking for prostitution is not a big problem in any event, and really the introduction of the criminalisation of the purchase of sexual services, that is it's inappropriate that should be in this particular bill. Have you a view on that, or are you just simply neutral on that, Mr. Harris?
I think you have to, as Royce set out, you have to look at human trafficking just beyond Northern Ireland as well. That if somebody, said, well, you don't have many instances of this in Northern Ireland, you've got 2% of the United Kingdom's problem, but we still have 3%, which is proportionate actually to the scale of the problem you would expect. So we are no better off than anywhere else in the United Kingdom, and we'll be no better off than the rest of Ireland either. Yes. And so that is then a significant problem given the scale of harm that this crime entails, and it's like saying you don't have very many murders, so why do you get worried about them? We have very serious crime and people been placed in this awful position, and I think it's incumbent on society to respond to that. And we as a police service have been very active in responding to this over the last 6 years, and we recognise it as the insidious crime that it is and the very serious crime that it is, and feel that we've responded appropriately. I think there's just something around in Clause 6, and it is the Assembly's decision, but as a society, how do we respond to this new phenomenon? 6 years ago, whenever this operation Pentameter was ran in Northern Ireland, we could find no evidence of human trafficking. When it was run again a year later, 18 months later, we uncovered cases, and it has grown from then.
Yeah, that's very helpful. Chair, can I ask a question?
By all means. It's your colleague who's looking in next. So.
Yes, in page 5, you talk about law enforcement activity to reduce demand for the product of organised crime has concentrated on public awareness rather than criminalisation. It is suggests that demand reduction is focused on awareness within the area of human trafficking. I couldn't really understand that. I found it difficult really to follow it. But basically you're saying that that something to do with awareness is a better remedy than criminalisation. That, to my mind, it doesn't really follow through. I'm not persuaded by that. I would have thought, just hear me out, I would have thought that if you criminalise the purchase of a sexual service, that's a huge deterrent. You do not want to be caught in that situation. Even if it's only a fine, or as they do in Sweden or places like that, it's still you've got the glare of publicity. You are being revealed to your family, friends, and everybody else.
Well, go back to the argument earlier. We can't be sure, because I think to go to a prostitute in this society would bring public shame when that was found out. In any case, now it's going to be a very public event if you're therefore then prosecuted in the aftermath. But I don't think it's either or. I think actually there's a lot of education is required around harm, which is prostitution, and I note in other evidence that people have talked about the importance of education as well, and awareness. And awareness is one of people actually knowing what they're looking at, what seems odd, what it might be, and therefore then obviously reporting it to the police. But education people in terms of just the actual reality of prostitution for the vast, vast majority of those who are within that industry.
Well, could we say public awareness and criminalisation rather than, and delete rather than criminalisation? Is that a fair alternative?
Fair alternative, and I would say we've made this submission. We're also being aware of how the debate is continuing to develop and move on, and probably will continue to develop and move on. And I think with implementation of this as well, we need to be aware of what happens next. And so being here today is just to further expand on our views in respect of this.
Yes. Thank you very much.
If I may just add on that, the view that we have of organised crime is that it's a supply and demand product, and for the most part, law enforcement is always about tackling the supply end, the people who supply the product, whether it's drugs or in these cases, girls for prostitution or sometimes men for prostitution. What we haven't done as a society is often to look at the demand side and to take away the enthusiasm of people to buy whatever product organised crime will want to sell you. And that's why we wanted to look at the awareness, because for a long period of time we were engaging with people in communities and the NGO sector, and there wasn't an acceptance that there was a human trafficking problem, so we needed to raise the understanding of it. And that's why Mr. Harris has said the very fact that this conversation is going on now serves the purpose that we were trying to do, just to raise the public awareness of the fact that this is happening, and therefore we can drive out the demand for it, possibly even shining a light on it.
Thank you very much, gentlemen.
Thank you, Mr. McGlone.
Thanks, Chair. I'll be very brief. Back to the Clause 6 thing again, because that's where obviously the question mark is. And you actually added to that question mark in your comments, whether it was adeptly done or whether there's basis for it, by referring to what the unintentional consequences might be. Now, that was either an unintentional remark or a very intentional remark. And if it were to be an intentional remark, therefore, from my point of view, it would be asked on what is that based? Is that based on experience of this type of legislation elsewhere? And if so, what is that the potential unintentional consequences of it?
What we would in particular be concerned about is the remainder of those individuals who, outside of organised crime groups, engage in prostitution, and actually the protection of them, so that in effect they didn't feel further ostracised or further removed from the police, so that they could not come forward and get assistance. There has been studies about people moving elsewhere and this been displaced, but we are an island, and what displacement, I'm not sure, may be a huge factor in this, but certainly protecting those individuals engaged in prostitution who are vulnerable would be an important caveat in this. We'd want to be sure that we still had lines of communication open to those individuals engaged in prostitution. We must be in a position that we can protect them.
So this brings us, if I'm following your thought pattern, this brings us to the very point that some have made. Do you feel that it has the potential in those out with the crime groups, the organised crime groups, to drive this underground, and therefore make it more difficult to realise and to get evidence that you would require?
Well, it is underground.
No, I mean further underground.
Well, the criminalisation of the purchase of a sexual service may add a further impediment, and it could reasonably anticipate that it may add a further impediment to individuals who are prostitutes coming forward to police to make complaints around serious matters, or to provide information to the police.
Right, that's okay, that's grand. That clarifies that. Now, the second bit was, I think it was yourself, sir, referred to the evidential opportunities would be limited.
Now, and I listened carefully to what you were saying. The evidential opportunities were limited, and it would potentially fall within a wider scope of investigation efforts. So, in other words, you're going in with a big hit about other aspects of organised crime, including possibly prostitution. And there's a bit of an add-on scoop of you guys round the edges who have been there. Now, that begs two questions. A considerable resource to catch a couple of individuals in a criminal act, and they then appear before the courts and are maybe fined a few £100, which they were scooped as part of a major effort. Now, that brings me back to the issue, and I put this to yourselves as well, the resource issue. You're obviously not going to put in a major undercover team, significant resources, significant surveillance, to wind up bringing a couple of people who've been indulging in prostitute or the act of commissioning sexual services, whatever, for a couple of £100.
Well, that is one of the challenges we would face. You know, we have to make the decision as to how we use our finite resources against the most serious harm that is in society. And as Mr. Harris has said, faced with an option of investigating prostitution that involves a woman who wants to be involved there for her own reasons, but if the legislation is passed, the purchase of that sexual service is a criminal offence. If that is the option versus an investigation into an organised crime group that is trafficking women against their will, I mean, almost 100% of the time we're going to be focused on that high-end risk, and therefore the resources are not going to be put towards the investigation of straightforward prostitution where there's no element of trafficking, and in fact where there is probably a significant element of consent from both parties.
Which really brings us back to the point, if I get the logic of where you're going, that would scoop people in circumstances where the operation is part of a wider catch-all operation on organised crime and aspects of organised crime, but at the edges it has the potential not just to scoop people, but to drive the prostitution and the flow of information from prostitutes to the police further on the ground. Is that,
that is it, and in some ways we're looking into the future of implemented legislation and trying to anticipate the risks or what reasonably may happen. I suppose that set of issues, and I think it would be a disadvantage to us, it would be a significant disadvantage to us to lose that contact that we have. Has to be set against the wider message that in effect society has set out about prostitution and the wider message that sends to organised crime groups now. And I think then that is a difficult judgment to make, a difficult thing to balance.
Okay, thank you for that. Thanks, Chair.
Mr. Lynch.
Yeah, thank you, Chair. It's just a follow on from that, and I think you said it right about the importance of focusing on the large groups rather than down at where there's no evidence of trafficking and consent. So how important is it to distinguish between consensual paid sex and those who are trafficked or coerced?
I think the reality will be that given the priority we have to give to serious harm, that and the amount of organised crime work that we have, that the folk and also the scale of the evidential requirements, the scale of the operation that we'll have to put in place, that our effort will predominantly, in the vast majority of occasions, be directed towards organised crime groups.
Yeah, just to follow on, Chair, thanks. I think earlier you said that Clause 6 could hamper evidence coming from sex workers of those who are being trafficked, and it could break those lines of communications. Is that true?
Well, the activity is covert and clandestine at the moment, for the most part, but there is opportunities for us to understand the picture, and that allows us investigative lines of inquiry. For instance, and as a matter of public record, there are various websites which are touted as escort sites. Now, you know, that's not fooling anybody as to what escort actually means. Now, if selling an escort service is synonymous then with selling a sexual service, well, actually overnight those websites would go underground or would shut entirely. Now that obviously denies us an opportunity to understand the nature of the picture of prostitution in Northern Ireland. So there's one potential risk that we would have to consider.
Mr. Humphrey.
Thanks, Chair. Thank you both very much for your presentation. I have to say, Mr. Haas, I very much agree with your assertion in terms of prostitution, that it is underground. It is driven underground, because if that were not the case, then your organisation and police forces throughout this kingdom would have much more information around this issue and statistics, and actually is the case. Do you agree with that?
Well, yes, it is clandestine in its type, and that is one of the principal issues for us, is that it is hidden from view, and we only become aware of it through proactive investigation or complaint.
Yeah. And I mean, would you also agree that we're actually dealing with, and I was part of the delegation that went to Sweden to look at this and discuss it with the Stockholm police. Would you also agree that we're dealing with very sophisticated international criminals who very clearly, not just in this jurisdiction but throughout Europe, most of the European Union, are actually involved in this criminality, but because of their sophistication, are very skilled at avoiding detection in both here in Northern Ireland and across Europe. So, the difficulty is that surely, if whether Clause 6 is, if I'm a cricketing umpire, if Clause 6 is introduced to take away the corridor of uncertainty, do you think that Clause 6 will make that worse?
Well, in terms of the national and international element for us, we do work closely with both the National Crime Agency and then on out into Europol. We have been involved in a joint investigation team, and so there is lots of sophisticated law enforcement to be brought to bear. But I'm not sure actually what impact Clause 6 will have on that more international picture. Sweden undoubtedly still has prostitution, and some of it is internet based and some of it is off street as well.
And on the international element, more often than not, those that are from an international background are involved in trafficking as opposed to prostitution on its own. So it is towards the higher end of it, and they do provide that level of sophistication and investigative challenge, not least of which because they are moving seamlessly across the European Union.
And that's the point. They're moving seamlessly across the European Union. Made the point on a number of occasions. The previous delegations making presentations to this committee, we were told of people who were being used as prostitutes in Stockholm, but they were actually, the phone calls were going directly to Bucharest. Because the young ladies were from Romania or other Eastern European countries. So therefore, the point I'm making is, even when resource is put in the magnitude that it is in Sweden, it is underground. It is underground. This is not going to force it underground. It is underground, because these are sophisticated international criminals who are exploiting young ladies in particular in the most evil way. So, it's a judgment, and some people will have their own opinion on it. I believe, my party believes, it is our duty to protect the most vulnerable people in society, and that's what we're about trying to do. Can I also ask then, in terms of Northern Ireland, and obviously we have a history of, over the last 30 to 40 years, of paramilitary activity and criminality that flows from those organisations. Is there, or have you any evidence of linkages between paramilitary organisations and this type of organised crime through trafficking and prostitution?
Well, about a decade ago, there was some indication of the involvement of some paramilitary groups in prostitution, but As Roy has described, this has now an international element, and those groups just do not have the international reach, because you do need an international reach to intimidate and terrorise families back at in effect, their home countries. We were involved in the Operation Describe in respect of phone calls being routed through the Budapest, and indeed we've presented in our part of that operation both to Europol and Interpol in terms of good practice. So we believe that we are at the leading edge in terms of enforcement activity around these OCGs, and we're very pleased then to help our European partners in respect of this, and we've been involved, as you will be aware, in a joint investigation team with the Swedish in respect of these very offences. We sit here not without hope that we've invested in the training of specialist officers, but we've also invested in the training of the rest of the organisation about awareness and how to recognise that, and we've also then worked closely with our partners in respect of that. So our ports officers have all received training around identifying telltale signs of human trafficking, as has the UK Border Agency, etc., so that ourselves and our partners who are on the airports and the seaports have an awareness of the signs to watch for, and we have been successful in identifying people being moved under coercion.
Well, you mentioned that, I think you said Northern Ireland is 2% of the UK's problem in this issue. I think we represent about 3% of the UK's population. So I think and taking from that, you're saying it's no better or worse than other parts of the kingdom. The difficulty that we have in Northern Ireland is for you, but it's an advantage to those who are involved in this sort of illicit behaviour, is that we have a land border with another European state. And the committee recently visited the Dáil and met with the All Party Group, or equivalent committee there, and there seems to be all party agreement on some sort of movement forward in terms of legislation on this issue. If the Republic moves to address this issue, puts legislation in statute, and Northern Ireland doesn't, I mean, would you fear that this will create a soft underbelly for prostitution and human trafficking of prostitutes in Northern Ireland?
Well, organised crime groups are very adept at finding weaknesses in law enforcement, and one would anticipate that they would try to use that weakness. I think one has to recognise that people, individuals who use prostitutes, do not seem to travel far to do so, and so whether there be a lot of movement from the south into Northern Ireland for this, it would be hard to envisage, but we do enjoy good cooperation with Garda Síochána. We do enjoy the sharing of intelligence. All of this is written into an intergovernmental agreement of 2002, and we are very active with the Guards around sharing criminal intelligence and trying to identify then criminal gangs that are operating across the whole island, because we do recognise that from afar that border can seem to be a point of advantage for an organised crime group.
Okay, and I'm reassured to hear that there's that good cooperation, because that I think is vitally important, and it will be particularly important if legislation doesn't follow here at a greater level. Finally, can I ask you, the failure for the National Crime Agency to be completely implemented in Northern Ireland, how is that? Is it, and will it affect your operation on this? And also, do you have the resources, because it's not fully implemented, to deal with this problem?
Well, a couple of elements around the National Crime Agency and hopefully its operation here. Obviously, there's been the issue about accountability, and hopefully that can be resolved. But actually, the practical impact for us is being felt, where we can seize funds through criminal route, the seizure of criminal assets. The NCA is responsible for the seizure of civil assets through the civil proceedings, and so given that this and other organised crime group activity is all about the cash, that is an underbelly for us, a weakness. Secondly then, the NCA has been a very active partner already with our colleagues in England, Wales and Scotland. And where you have an operation, a big operation against an organised crime group, they have in effect lent officers to other forces, so you have a surge capacity in respect of detective resources and etc., and that has been a great advantage that other...
And you can't avail of that?
We can't avail of that at the moment, and so that's significant.
So Northern Ireland and as Mr McGuinness called the indigenous people involved in this industry, or people trafficked in Northern Ireland, Northern Ireland is left more vulnerable because the National Crime Agency is not being fully implemented. Because you're not getting the resource that other forces across the mainland are. Well,
at the beginning, these vulnerabilities would have been difficult to start to anticipate, but now 6 months without, or 5 months without the National Crime Agency, we can start to really see where cracks are opening up, and we are really very hopeful that we can get accountability issues resolved, because we are missing out on the operational assistance the NCA can bring.
And finally, Chair, you've briefed the Justice Minister on this, I presume?
Yes, Justice Minister is aware.
Thank you.
Thank you.
Thank you very much, Sharon. Thank you for the presentation. You've said in your evidence that most of the prostitution is by independent sex workers and not as much by people who are coerced.
Yes.
But you've also said then that in your evidence that the deterrent value of the legislation is then minimal. It would be minimal, in that persons using prostitutes do so in a clandestine way. So can you elaborate a bit more on that?
Well, I suppose the industry, it's very hard for us to say what proportion is with organised crime groups and what proportion is prostitutes who are acting individually, but by far the bigger proportion of those prostitutes who act on their, in effect, on their own. And as I've said already, Northern Ireland is not a society where prostitution is commonplace or accepted. You know, we've not been a society where prostitution has been very open. It's not been. We haven't merged situations in big conurbations in the Midlands where prostitution for years was a very open event going on. So I think just the nature of our society means that those who use prostitutes are already taking a significant risk around their reputation, and it's very difficult to determine what further impact this would have on their behaviour. It may have some, certainly if there was prosecutions and those were publicised, as there would be, that may then, the actual application of the law, successful prosecutions, may have a deterrent value. Unfortunately, we've not had successful prosecutions around those individuals who've used prostitutes who have been trafficked, and hopefully we've resolved that in terms of the statute limitation, that those offences were coming statute barred for summary offence in the middle of what was a complicated prosecution which was taken forward on indictment, and so the two time scales are not compatible.
I mean, yeah, I believe it's very important that statute bar is lifted, so that you know that.
Yes, very much. Yes, we would see that. We would see that important, important in terms of just clamping down on human trafficking, and we're glad. We are very pleased that will soon be resolved. But we have to say that this has been a developing picture over the last 5 years, and really that we started almost from a standing start. And as we've learned, then the legislation has been developed, and that's why we do, as I've said, welcome this debate, because it's part of the wider debate that we as a society need to have about our attitudes to prostitution and vulnerability, and the vulnerability particularly, obviously, of those engaged in the industry, both men and women.
And we've heard a lot of evidence, as you know, and as you said there, this has become a much wider debate, and I think it's a good thing, because it's very complex, and it's complicated. There's so many aspects to it. But we've heard from people, and when we've said, there's laws in place, because it's a human trafficking bill, and human trafficking by its nature involves coercion and force. And there are laws in place which make it a crime to use someone for sex if they are coerced, or if there's abuse involved, or if they're underage. And but what they've told us is, but there have been no prosecutions, and it hasn't been effective, and it hasn't resulted in reducing human trafficking. So what they're saying is that then this law is required to make prosecutions more common. Now, I'm wondering about. Do you think that would be the case? Because if you bring the law in, it means people, as you were talking about, who might be doing this maybe in an openish sort of way. I'm not sure. I don't know how openly people do it. But let's say people who were doing it openly, then obviously they're going to become secretive about it. So, I
don't think we see.
What I'm saying is then. Is it likely to deter people who would be coercing people?
I think what we see is,
active to this law.
As Mr. Humphreys has said, this is a clandestine activity. People are not, in our experience, advertising the fact that they are visiting brothels or going to single-person prostitutes. And as Mr. Harris said, the moral impact on them, if they were exposed to public understanding of, they were arrested or prosecuted for this, would have an impact on them undoubtedly. The fact that if they're being exposed to visiting a brothel now and they're not prosecuted, that can be as powerful because of the social stigma that we think is attached to the visiting of a prostitute. There have been prosecutions. There have been prosecutions for trafficking, for sexual exploitation. In the course of one of our investigations that took a considerable period of time because of its international complexity, we did visit 6 men who had visited girls who had been trafficked, and we interviewed those and put papers to the prosecution service, only to discover that unfortunately the statute was limited to 6 months, 6 months from the date of their visit to the girls. Now, that's a lesson for us, in which we're pleased to see will hopefully change the legislation. But we have brought prosecutions forward for trafficking for sexual exploitations. Now, the impact of that, well, we know from our most recent investigation that the reach and the ability for us to engage with the European partners, especially the crime groups, have probably not really appreciated our capability to reach into those other European communities to take them on, because this is a global problem. It's not an Irish problem, it's not a British problem, it's a global problem, and we're simply one of hundreds of destinations that people are going to. So there is a necessity to take this forward, the investigation of human trafficking on a global basis.
Okay, I mean, and you've outlined there how that's a focus of how you operate, that you're after the criminal gangs and you're taking an international view of it, and that's focus. So would Clause 6, do you think, make any significant difference to that?
Clause 6 would be targeted at the people who are buying the service as opposed to those who are trafficking people. But it would be wrong to say that there isn't a connection one to the other. It is a service that is being delivered because there is a demand for it. Now, if Clause 6 has a positive impact insofar as it reduces the number of people who are saying, I don't want to be at risk of being prosecuted, if that reduces the supply or the demand side, then it has an impact on the supply side, if that makes sense to you. Mm-hmm. So if it has an effect of driving out a number of people who would otherwise at this point use or visit a brothel or use a prostitute, if it drives some of those people back to, well, I'm not going to do that because I could be prosecuted, then that has an impact on the supply and demand side. And organised crime is fleet of foot. It seeks out profit where there's least risk, and if there's a risk of being caught and prosecuted, then they'll move into something else. So there may be a positive insofar as driving out, having an impact on the business, but we don't actually know until we roll the dice on this one.
Okay, so can you say something more about your investigative difficulties? Because we heard in Sweden that what this told us was that they wouldn't be able to get prosecutions if they didn't have access to wiretapping.
If you take at one end of the extreme, we have an organised crime group and at the other end, it is consensual prostitution where adults, male and female, agree to participate in a sexual act. At one end of it, there's a level of risk is quite low, and at the other end of it, the level of risk is quite high. The seriousness of the criminality allows us to engage different legislative tools to use various covert means. As you get down towards the lower end, where it's consensual between a man, if a woman decides to be a prostitute for her own reasons, there's no threat, there's no violence, there's no force, it's an independent, conscious decision to do that. She's not broken any law at that point. And if she then offers herself for sexual services to a man, that is a consensual, potentially a consensual agreement between two adults. If the law is passed, then it obviously is the purchaser of the sex commits a criminal offence. Now, for us to use covert means, we need to reach certain thresholds for us to do that, and that scenario may not allow us to do that. So the gathering of that evidence could be between us trying to find evidence of a consensual agreement between an adult female and an adult male in the privacy of, a hotel bedroom, and that raises all manners of difficulties for us to try to do that in terms of the Human Rights Act as well.
To explain just briefly in terms of legislation, before you can use the most intrusive means of surveillance, the offence that you are directed against must be one in which a person over the age of 21 on first conviction is likely to be sentenced to more than 3 years imprisonment. So that is a high threshold, and obviously this offence, as indicated at the moment, has only 1 year as its maximum. So that is why then, practically for us, in terms of all the investigative tools we might wish to use, and a lot of those would be around surveillance, that we would act and look towards investigations into serious harm where there was offences in respect of human trafficking, offences maybe in respect of rape, serious sexual assault, grievous bodily harm, those sorts of offences.
Would you see there being difficulties in trying to get proof of purchase?
Yeah, I think there is. In one scenario, a girl who is voluntarily putting herself forward as a prostitute. In some scenarios, may put themselves forward as almost like a business enterprise. They have committed no crime, but the person who buys the service of them commits a criminal offence. We may be asking that person who has voluntarily offered themselves to give evidence against their client. And I foresee some real challenges where there'd be an unwillingness to do that, because a lot of the business that we're talking about here is built on reputation. Some of the websites allow people to carry out a review of the service that they've got. So you can just imagine, from an economic business point of view, they're not going to want to put themselves forward and say, well, I went to this person, but they then give evidence to the police about the deal that she had in fact offered. So we see some of the difficulty, and that's even before you get into, as the picture we painted, the use of covert and quite highly intrusive and certainly very expensive investigative techniques that we would want to use in other more serious crimes.
Okay.
All right, thank you. I'm going to bring in Mr. Dixon, but before doing it, there's a couple of things get raised and you sort of take note and think, I want to follow that up, because there's sort of more questions coming in as we hear the evidence. But that threshold for covert, 21 years, 3 years, is that necessary if you suspect the victim has been trafficked?
If you're investigating a crime of human trafficking, then the criminality has to meet that threshold, which is applied under the Regulation of Investigatory Powers Act.
Well, that is for the intrusive surveillance.
Yeah.
Which is a specific form of intelligence within the Regulation of Investigatory Powers Act. But these OCGs, they breach these thresholds because of the seriousness of the crime that they're engaged in. But if you go outside of the work of the OCGs to single actors in terms of providing or prostitution, they will not breach that high-end surveillance. You may be able to mount surveillance, but it may not be all that you would need in terms of an evidential outcome.
I understand the Swedish system is different in the sense the prosecution service seem to be very much involved in directing investigations.
Yes.
As opposed to here. So I understand there are differences as to how they can get over the line of wiretapping and those type of processes, although they seem to say Human Rights Act, human rights legislation in Europe applies to us as much as it does in Northern Ireland. So because we asked them these type of questions, how do you overcome this? And the prosecutor who leads a lot of this investigations couldn't understand why this was even being raised as an issue, why it was difficult in Northern Ireland, because they have the same human rights.
But it's the legislation that has to comply with the human rights that and times create
Well, the European Convention is the same, but the Human Rights Act and the legislation that has flown from it, has come out of that, is very much UK based.
The comment about how much, I don't know if you said minimal impact in your presentation. I think it was sort of unquantified. You're not quite sure what impact the deterrent value would be to the ordinary person who would use a prostitute. And this came from the Swedish Police Service, so I've no reason to suggest why they would tell me different. They said that Clause 6, the deterrent value was to reduce it approximate by about half. That was the deterrent value, which then allowed them to put their resources in the harder cases. But as a deterrent value, it was reduced by about half. So why would we not have that same kind of deterrent value?
Well, we would hope to have a deterrent value. I'm not sure I'd be able to quantify it, but we are at a different place. This legislation was introduced in 1999, and I believe that the particular problem then was on-street prostitution, which was very, very visible in their city centre. They, as well as ourselves, the character of prostitution has moved on in terms of how it is made available, in that it's internet-based and off-street. And so the overall deterrent value may have changed. We would hope that it would have a significant deterrent value, because prostitution in itself then can encourage then other forms of criminality, or it is connected to other forms of criminality as well, particularly for an organised crime group. And so we find ourselves walking a narrow line around the organised crime groups, serious harm, but also then public nuisance, public well-being, but also then the vulnerability of those who engage in prostitution as single actors. And so there's a difficult and narrow line for us to operate on, and Clause 6 in particular may change some of that relationship. We'd hope it would be a deterrent. It's hard to quantify how much.
Finally, and then I'll bring Stuart in. Mr. McComb, I think you said that one of the unintended consequences may be internet sites shut down. Now, the Swedish police showed us how they track people through the internet sites, and they've had the law in for quite a number of years. So why, if the law in Sweden didn't result in internet sites shutting down, why would it have that impact here? And if you want to answer this last question together, they indicated that evidence from the victims was very useful. It isn't just Clause 6 in isolation, it's Clause 6 with the decriminalisation of the prostitute.
Yeah.
And those two hand in hand meant the evidence was more forthcoming from victims. So if you could maybe touch on the internet and victims.
Well, in respect of victims, then you're talking about human trafficking, which is clearly a matter where we would want to focus our efforts. Where you're talking about circumstances where people are voluntarily acting as a prostitute, who's the victim? We don't potentially have a victim at that point. It's a consensual act, and the willingness of that person to cooperate is a question. I'm not so sure we're going to get that level of cooperation. Professionally, I don't know that if you're going to run a website that you call an escort website, which everybody knows is for the purpose of engaging in a sexual sale, if you then make the buying of that service illegal, I think there's a real risk that those sites would be put off the market or become part of the dark web, that part of the web which is harder to get to, but you need to be more enthused to be able to get to it. And that's just the judgment we have at this point. Because the legislation hasn't passed, we don't know what the actual impact is going to be. It's just that professional judgment at this point. But
it is hard to quantify, because Sweden does have a lot of sites offering escort type services still, and so the websites are also obviously an area for investigation for us as well. So we don't know what that impact would be in terms of websites coming down, not sure.
Would you see, Mr. McComb, the consensual prostitute being applied to, as the evidence we've came forward is, there's human trafficking victims put into sexual servitude, but the vast majority of women involved in prostitution didn't have a choice. They came from broken homes, they had a drug problem, they had an alcohol problem, they had mental problems. Okay, they weren't trafficked into Northern Ireland, they're not being trafficked internally into Northern Ireland, but they're, I would nearly say, almost exclusively entirely vulnerable adults who have got issues. So are they really consenting adults?
Well, I accept that there's a spectrum of people who are on that side of the consensual element. There are people there who do have vulnerabilities. We absolutely accept that, and we're clear that we have that obligation to protect those people as well. But the experience we have so far is there's a number of people that we have spoken to who are making a lifestyle choice. They're making a choice for reasons that, you know, any of us may find difficult to believe, but they're there because they want to be involved in that activity. I mean, there are people that we have spoken to who are using it as a means to either keep a living, pay for a university course, pay off debts, a variety of legitimate reasons why people will want to do it. But I do accept, and there, of course, by the nature of the business, there will be people who will have vulnerabilities such as you've mentioned. Absolutely accept that.
And my final point is, should we, and I know this is a question for legislators, maybe unfair to ask you, but should we be, as I think it was the Human Rights Commission said, protecting the rights of that minority at the expense of the majority's freedom, who are being kept in sexual servitude?
I think someone who's been held against their will and being asked to participate as some sort of a sex slave, then that's a duty on decent society to do all they can to protect them.
Yeah. Mr. Dixon.
Chair, thank you, and thank you for coming on and helping us with what's a very difficult, complex situation to understand and to work around. If we could look first of all at the situation of those individuals who are trafficked for sexual services, and you've clearly set out for us a scenario where, in fact, for you, as in terms of police operation, it tends to be a bigger operation than just simply for sexual services being delivered. When you carry out those operations and you enter premises or whatever, if there are women present, for the sake of discussion, if there are women present who are clearly distressed and in what to any reasonable person would be a horrible situation, are your officers trained to, for the sake of argument, presume that they are trafficked people? Is there a presumption of traffic?
Yes,
and therefore, until you can prove otherwise that they're not actually trafficked at all, that they will be treated with the appropriate services of someone being trafficked?
Yes, is a short answer. The officers that I have the privilege to lead, when we use them for these types of operations, they have been exposed to training to understand the signs and the images and the sort of the presentation of people who are trafficked. Yes. Now, they're simply indicators. It's not of itself evidence. They're trained to try to build up the trust of the person, and we conduct ourselves in a way that we try to separate the person to individual rooms so that they're not being spoken to in the presence of somebody who may be the trafficker, who may be the controlling force. So we try and separate people out so that we can have the conversation to try to understand, who's who in this situation.
And they would be treated with appropriate sensitivity. How quickly, for example, would you have someone who could translate for you so that you're not screaming at somebody in English and they're using very poor English skills?
I would hope we'd never be screaming at anybody, but when we're leading intelligence-led investigations, we often go into these environments with a level of understanding as to who's likely to be there, including the language that they may be spoken. So part of our planning exercise, where we have the opportunity to plan as opposed to having to react quickly, part of our planning is to have all of those agencies available to us as soon as practically possible. The police service have the ability to have an on-call telephone translation service, so we can literally put somebody on a telephone in the middle of the hotel room or bedroom or flat or wherever it may be.
To what extent is the current failure to have access to the National Crime Agency hampering your efforts? Now, I appreciate that you have good cooperation across a wide range of organisations, agencies, but is there a particular point that either frustrates your opportunities, or that you have to do circumventions that are time-consuming?
Well, as just to reflect what Mr. Harris has said, there is an invisible barrier there, that is the border with Northern Ireland, that the National Crime Agency can, and in fact have led investigations of an international nature, not specifically in respect of human trafficking, but in other matters, which they have had absolute control, absolute primacy, and at the moment that it comes into Northern Ireland, the PSNI have to then pick up what was an NCA-led investigation. Whereas the same situation in England, Wales and indeed Scotland, the NCA would simply carry that through. So if our job is to protect the vulnerable and to take away the really serious criminals, we don't really have an option to say, well, you brought this far, but we can't really help you, you're on your own. So we're professionally obliged, but not legally obliged, to pick that up and say, we will then take it from here at that point. Now, that enables us then to carry on and do the right thing, but we have to make the judgment to say, but other parts of our business that we're doing have to be put into some abeyance for a period of time. So there is those practical issues that we are seeing, that international investigations are having to be supported in Northern Ireland, whereas in England, Scotland and Wales, they're simply carried on by the NCA.
Okay, thank you. With regards to the statute bar period, there are plans, I understand, to extend that to allow for prosecutions. Is that something which you would welcome, and what are the practical outworkings of that for you?
Yes, we raised this with the department, and with one mind we thought that this is something that we would like to see fixed. The nature of the investigations we do into organised crime and human trafficking, human exploitation, they're not oftentimes quick operations. They do take a period of time. Our focus is about rescuing the victims. So the individual who has visited a trafficked victim and has bought a sexual service from them, is down the pecking order, as it were, in terms of what we're trying to achieve. We're after the organised crime group. And unfortunately, in the 6 occasions that we went looking, in the one operation, the 6 men that we went to visit, it appeared that the legislation didn't enable us to do that. So, we wanted to investigate and bring prosecutions against 6 people who had been involved in the abuse of traffic victims, and we weren't able to do so because the legislation limited the time.
Turning to the experience which we had in visiting Sweden and looking at the model which the police deploy in relation to dealing with these matters, while you've said that in relation to phone tapping and internet interception, that comes at a high level in terms of the criminal offence being undertaken. The little piece of video which we saw of an operation was very much of a low level, consensual, if you like, activity where there was no court intervention, no authority given other than that at police superintendent level, which was the level which the law in Sweden permits interference with telephone communications. And that went on to include the placing of, I suppose, microphones, whatever you want to call them, on the walls of the adjoining room. Because you obviously have to get to the point where the consensual act takes place, because conversation is not illegal, or sitting on a bed beside somebody is not illegal. What effect would that have on the resources of PSNI, were that to be what society would be demanding of you should we implement Clause 6 in full?
Well, that which you describe in Sweden is not possible within our present legal framework of how we would operate. It would be classed as an intrusive surveillance under our own legislation. And so, again, why both Roy and I have emphasised then how our focus would be on organised crime groups and serious harm, because that allows us then all the legislative implements that we can bring to bear in terms of all the tactics that we might wish to apply.
Finally, Chair, just briefly, in the PSNI submission to the committee, what you've said in your final paragraph, I think it's your final paragraph, is the criminalisation of paying for sexual services of a person is not supported at this time. It is suggested that further research is conducted into the prostitution environment in Northern Ireland, and this may involve wide-ranging prostitution legislation. Support of persons involved in prostitution is also a concern, and this legislation does not assist in such support. Is that still the view of PSNI?
Well, I think I've given a more nuanced view. We have discussed this as a command team, and I'm representing the views of the Chief Constable when I've given a more nuanced view in respect of the application of Clause 6. I can see, as I've said, issues around deterrence, issues where it would be a deterrent to prosecute somebody as a result of an operation in an organised crime group, but we're also then concerned about flow of information and further driving other prostitutes away from the police service in terms of both providing information and secondly seeking assistance from the police.
And on that basis, are you actually saying to us, and potentially not disagreeing with you on the serious crime side of the discussion, are you saying to us that in fact Clause 6 as it's currently written doesn't achieve all of your objectives, or doesn't, is too broad in its concept, and that perhaps we may look at how it could be reworded to put more of the focus on the organised crime aspect?
Well, they're already, with the legislation that we have and the statute barred element repaired, you do have a focus then directly on those individuals who've been trafficked for the purpose of prostitution. This then catches then a further group of those where we would be involved in respect of organised crime gangs who are using prostitutes to make money, where we're not able to illustrate, prove the trafficking portion of it there. We have instances where individuals, women have been trafficked and controlled by other women who at that times have acted as prostitutes as well. So as part of the controlling function, I suppose if the demand is there, they also act as a prostitute, and that would be where, again, we would wish we could use this legislation to bring a further prosecution against an individual who used that woman as a prostitute.
Okay, thank you very much.
Okay.
Thank you, Chair.
I think it is worth trying to bottom out exactly your position on it, because the public will just want a very simple, are you for it, are you against it? And I just want to try and encapsulate where exactly you are. And my reading of it is you have moved on from what the submission was, yes, because you've looked at it as a command team. Yes, you've been listening to the debate and the evidence coming forward with that debate. And it's now at a position of you don't oppose Clause 6, but there is qualified support for it. Is that?
There's qualified support there's impacts which are hard to determine at this stage, if they happen. But there could be positive impacts, which again are hard to determine now. If we were able to bring prosecutions, and this was a substantial deterrent to individuals who want to use prostitution, that would be a public good, and it would be a public good and for this society.
Okay. Mr. Wales?
Interested in your definition and description of the prostitution industry, and I managed, for some reason, documents keep falling into my pigeonhole on this issue without any indication of where they came from anonymously, and yet again another note have come in from the police and the Department of Justice, so I think it's worth refreshing your mind as to what your view on this is. Philip Marshall on the 25th of the 10th, PSNI of course, was asked for his view on what constituted the prostitution industry in Northern Ireland. He said, I have a number of key points. 1, he believes that 1 to 2% of the women involved in prostitution in Northern Ireland are there by choice. 1 to 2%. So that's somewhat at odds with this consensual, happy career choice, doing it voluntarily. He says 1 to 2%. He says, of the women contacted by the Belfast Commercial Sex Workers Service, 87% had suffered depression, 19% had attempted suicide, 87% had been physically assaulted, 40% had raped, and 55 had been raped, and 55% had experienced homelessness. Now that paints a rather different picture to me. That in your original paper, that the majority of prostitutes in Northern Ireland are career women who made the choice and are content with their lot. Well, if they are, it's a pretty awful lot. And that's not my words, that's Philip Marshall's words. But there's more. Yes, go on. Do you want to know a bit more? Because in a paper published, again, this didn't drop into my Reducing Offending Among Women, Department of Justice 2013 to 16, it says, this is again about prostitution, women are involved in prostitution for a variety of reasons. Some enter through personal choice, others are driven to it by desperation for money, typically to provide for their family or an addiction. Some are trafficked either from Northern Ireland or into Northern Ireland from another jurisdiction. Most are controlled or exploited by a male partner or pimp. Again, not a very glowing reference for the industry in Northern Ireland. Now, if that is the case, then are we not dealing with a large number of very vulnerable women who really haven't a choice at all?
Well, I don't err from either of or don't move away from either of what those documents have said. I've highlighted in my answers and my evidence that we are concerned that all of these women are on a continuum of vulnerability, and that vulnerability is from grave danger through to the danger of assault, sexual assault, rape, as is highlighted in those statistics. And that's why there may be a benefit in this in terms of the deterrence that it may offer, the signal that we're setting out, that actually the Assembly sets out as a society of our abhorrence around the vulnerability and the abuse of vulnerable people for prostitution.
Well, if 99% of them are there because they don't want to be there, that's a very, very difficult position those white women find them in. Also, the 17th, 18th and 21st IMC reports found dissident Republicans involved in organised prostitution in Northern Ireland. Do you stand over those reports?
Can you give me the
17th, 18th and 21st IMC reports found dissident Republicans involved in organised prostitution?
Well, I wouldn't contradict those reports, but there's no information at this moment in time to suggest that dissident Republican groups are involved in prostitution that I'm aware of, and certainly...
Sorry, I just want to add to that. Sorry, I didn't want to interrupt you. The time periods for the 21st report, what's the latest date?
That was, again, dropped into my pigeonhole. I don't know the name of the date. The 21st must be quite recent.
2010. 2010 or 2011.
The question earlier on about the role of paramilitaries, we have seen the smallest number of people involved, but they have been displaced very rapidly. In fact, in one particular instance, we had people who would have tried to, in organised crime more generally, where prostitution was just one element of it, prostitution as opposed to trafficking. And what started out as this particular group having an element of foreign nationals supporting them as the muscle, quickly that became inverted, where the paramilitary group became the muscle on behalf of the organised crime group, which was led by foreign nationals. So they were displaced by foreign national groups. But that's historic.
Well, that must be great comfort to the women who are locked in various apartments in Northern Ireland being abused for sexual services. That a different cohort of victimisers are in charge of their destiny, but it's still a very worrying situation. In DOJ, a report published by the DOJ in 2011, it stated that 85% of the men in Northern Ireland would change their behaviour if there was a risk of a conviction under the equivalent of what has now become Clause 6. 85% of men in Northern Ireland. And I put it to you that, particularly in rural communities, if someone of standing in the community, if there was a little tiny column in the paper said that Mr. Smith had been convicted and only fined £100 because he was caught in a brothel, the shame of that in a Northern Ireland context would have a hugely deterrent factor.
and I think we've said that
Right.
we accept the fact that there's a social stigma in Northern Ireland, that even notwithstanding today, as the law stands at the moment, if people are identified as having visited a brothel when there's no criminal offence involved, we accept the fact that that has a huge impact on them in society.
But if I mean, it wouldn't obviously, but if I visited a brothel today under the present legislation and I walk out, there's nothing you can do on me.
No, but
No, you haven't committed any
I
offence.
haven't made offence. So therefore, my name will not appear in the paper. But if you then stop me and said, Mr. Wells, you know, if you've just seen you coming out of that brothel, we're fining you £100. We're taking you back to your wife. I'd only do it the once, I can tell you. I'd only do it the once. And then I appear in the paper. I think that would be a big deterrent.
Well, even if you take the scenario where we did visit people using the 2009 legislation, and we did have, and it wasn't intended to cause domestic catastrophes, but I can imagine that was the outworkings of it, one of those unintended consequences. But we did knock the doors of 6 men, and we did have those conversations. Now, that didn't lead to a prosecution, but I would be not at all surprised if actually the consequences of that was the follow-on conversation was far more difficult than what conversation we had with that person at the door.
I would certainly knew my wife. I would say it was a very difficult conversation.
Absolutely, and we accept the fact that there is that deterrent value in that, and we've accepted that in the evidence.
Yes, but then that leads on to the issue that the Swedes, and I do have to say, I hope you've been on the plane. I mean, I don't normally support the police going off on various foreign trips, but I think this is one you should be making. Because the Swedes, and we spent a very interesting day with them, they have told us that their stats would indicate that the demand by Swedish men for prostitution services halved. And that's against a backdrop of countries like Germany and the Netherlands, where it has rocketed. So therefore, the impact has actually been more than that.
Well, I certainly haven't been to Sweden, nor has Mr. Harris in respect of this legislation, but we have conducted a joint investigation with the Swedish police, so I've had investigators embedded in Sweden for considerable periods of time, and if you'll allow me to present it as second-hand evidence from them, their experience is different. Their experience is not that it has had that positive impact. Their experience is actually that there is still a significant prostitution problem in Sweden, and more so, there's still a significant human trafficking problem in Sweden. It is not the on-street prostitution, it is the off-street, more clandestine and more sinister insofar as human trafficking. And allow me, and insofar as the second-hand information, those are my detectives, those are my senior investigating officers having those conversations with their counterparts in the middle of an investigation that was focused on human trafficking.
Yes, I don't think that anyone who's supporting Clause 6 is saying it's going to wipe out prostitution in Northern Ireland. I think we accept that. But the Swedes have measured their performance against somewhere like Germany, where the graph has gone so sky high. You know, in other words, the growth that would have been stopped. Other very interesting statistic they told us, of the hundreds and hundreds of men, and the vast majority are men, who they've intercepted, taken back to their wives, and fined, and the names appeared in the paper, the re-offending rate is amazingly small, which indicates that the shame of what they've done clearly registers, so they don't find the same customers coming back time and time again.
The social stigma today of visiting a brothel where there's no criminality, I think, is significant in Northern Ireland. If that was publicly recognised that Jim Wells visited a brothel, the social stigma is huge. I absolutely accept that.
It'd also be ex-MLA as well.
The additionality of Jim Wells being exposed and prosecuted for that adds to that. We accept that, but
that's just what I mean. And I say, unless the Swedish prosecutors, social services, and police are telling us, importance, I'd have to say that their evidence, as the evidence from other countries like Iceland that have done this, would indicate it does suppress demand, but it doesn't wipe it out, and no one's pretending that it will.
I think we would try to express a caution that you have to compare like for like as well here in terms of legal systems, societal attitudes, social pressures, the prosecution service, the attitude of the prosecutors, the evidential issues, the evidential processes, the investigative processes. Those are things which have to be seen in the mix.
There's an argument going round that you can't, I think the words conflate prostitution with trafficking. Why in July 2011 did Douglas Grant who's a senior police officer, I don't know that gentleman, he's known as Doogie apparently, but I think his proper name's Douglas, that he decided to merge the trafficking and prostitution units within the PSNI. Why was that done?
Well, for a start, he didn't, I did.
Oh, right, well, sorry about that. He announced it.
Well,
he took the credit.
Doogie at that point was the what we call the service lead. He's one of my detective chief inspectors at this point in time, and we did not have a standing prostitution unit. We did have a core, quite a small cadre of people who had experience of human trafficking. And recognising that this was an emerging and increasingly difficult issue, and that there were overlaps between human trafficking and prostitution, I merged the concept of it and the service lead issues and called it human exploitation, because there are two elements to it. So there is an overlap, but they're not synonymous one with the other.
But it is interesting you made that decision because you could see a very clear overlap.
Oh, I accept that.
Prostitution and trafficking.
Absolutely.
So those who are saying you shouldn't link the two are frankly talking to their hat.
Well, no, we don't support the idea that there is no link. What we do say is that there's no absolute link. They're not mirror images one of the other. You can have a human trafficking that is not at all linked to the sex trade, and you can have the sex trade that's not at all linked to the human trafficking trade.
Okay. You said that, I mean, you tended to add some weight to this argument that it drives it further underground. Yet, interesting, and again, the Nordic countries haven't suggested that's a problem. Why, if someone needs to make contact with the provider of sexual services on the internet, why, if he can do that, why can't the police make the same contacts? I mean, you know, by its very nature, if you arrive in a town and you want to acquire the services of a prostitute, you have to have access to the information to obtain those services.
If you take the scenario of buying drugs, it's for the most part not freely. You can't just look up a Yellow Pages and on order. Pardon?
No, you can't. You're right.
No, you can't do that.
Yes.
And the reason for that is that it's a criminal act. You're involved in a criminal act. So if it was not a criminal act, you would see Yellow Pages, you would see websites popping up. Now, so if you reverse that and say, actually, if you make something a criminal act, it's not unreasonable to think that today, which is something you can buy, which is not a crime, but tomorrow is, actually the accessibility of that information becomes much more difficult.
Yet the Swedes apparently had no problem whatsoever.
I revert back to the parallels between the Swedish justice system, societal system, and Northern Ireland, and whether there are absolute parallels there.
The French took a look at the Swedish system, and they're going down exactly the same route. It's strange that very different countries with different systems have all looked at the Nordic model and think there's something going on here. Because, well, okay, I accept your point, but I would have thought that, you know, the difference between drugs and prostitution is that we're talking about human beings that have to be accessed. It's rather more difficult than slipping a small packet of powder between one person and another. And I would have thought you would have had the ingenuity as policemen to track down the prostitutes using, I know they use...
I think part of the fear we're expressing is actually one of the vulnerability they're in, and will they report crimes to the police in the overall climate of Clause 6 being in place. So will they report assaults? Will they report sexual assault? And so we want to make sure we keep an avenue open for that they don't feel we'll just be focused on what is the criminality of those individuals who've used you as a prostitute.
Why, if you make the buyer the criminal, why would that make the person who's being abused less likely to report crime?
Well, that is what has been represented to us in correspondence.
Yes, and I'm coming to that. You quoted it, and I'm extremely worried about who you quoted. You quoted you're in correspondence with Ugly Mugs and Escort Ireland.
Well, they have sent me a letter.
Yes. Do you know what Escort Ireland is?
Yes, I do, yes.
It's the largest prostitution website run by Peter McCormick and Mark McCormick in Ireland. And I'll say it again, Peter McCormick and Mark McCormick, they're both prosecutions, they've both been convicted.
Yes.
And they're both perfectly open about what they do. They have 400 women being trafficked internally in the island of Ireland on a weekly basis, and that includes Northern Ireland. 45 of those women, as we speak, are in Northern Ireland tonight. They've been trafficked around. Now, Ugly Mugs, and I hope you followed the line of questioning I made to the Ugly Mugs representative, Lucy Smith. Ugly Mugs is quite clearly the front spokesman for that organisation. There's no question about it. So why are you regarding what they're telling you as anything but the voice of the industry? And they would say that, wouldn't they?
Well, they would say that, wouldn't they? But then you yourself have quoted to me the statistics around the vulnerability of prostitutes, and that is our concern. And I've highlighted throughout our evidence, our concern is around the vulnerability of those individuals, and they are on, as I've said, a continuum of vulnerability from very grave danger. And they are in danger of being attacked, either physically assaulted or sexually assaulted. And we want to be sure that they know if they come to the police service that we will respond properly in protecting them and investigating those offences properly.
And I think that's important. But to take your steer from a front organisation that's funded by the prostitution industry, I think is clearly very tainted evidence.
Well,
I'm not sure we're taking our steer from
No,
that.
no,
I think we make our own judgments.
Well, you quoted them several times in your earlier evidence. You did. You quoted.
Certainly not consciously.
Well, I think that we
I
quoted
haven't met
once
them.
the correspondence. We quoted once the correspondence that was provided to us. Ugly Mugs, though, does exist elsewhere and is used by Merseyside Police as a conduit to prostitutes in their policing area, and that fell out, or it was a consequence of the murder of a prostitute, and so we have to bear in mind the lessons and the awful experiences there's been both in Merseyside and Ipswich of the murder of prostitutes, and the need to be able to keep an avenue, a route of communication open with that vulnerable group of people. And that's, like, our position has changed. I think it's become more nuanced, but we can't know all of the impact of the provision of this legislation. If it is a deterrent that is described in Sweden, that is very good and is a public will be a public good, as I've already said. But we just want to have in mind to the consequences as well.
Yeah. It's worth saying,
if there are any consequences.
It's worth saying that letter you received, the Chief Constable, none of those people are from Northern Ireland. And equally, I must make it very clear that the Laura Lee lady has admitted in this committee that her International Union of Sex Workers includes the largest pimp in the northwest of England, Douglas Fox. So again, you must always treat this evidence from so-called prostitutes collective groups with extreme suspicion. And you'd be better to speak to prostitutes individually when they're not being coerced by their pimps or their controllers, rather than the so-called groups, which are clearly front people. Because the pimps can't come here and give us evidence, obviously.
But we do have experience of prostitutes being in a position of vulnerability and being subject to crime as well. That is the reality of our experience, policing experience as well.
But can I say, I welcome the different nuances and stance you have in Clause 6, because you've moved from a position of outright opposition to a situation where you can see some benefit from it, but you still have some concerns which you'll see in the outworkings.
Yes.
And that is a major step forward. Because remember, the folk have come out in Clause 6 and the screen has went off, but in Clause 6 it's interesting that the two organisations in Northern Ireland that are directly involved in the care of prostitutes in Northern Ireland, including Women's Aid, they're very strongly in favour of Clause 6.
Well, I've taken notice of their evidence as well, and I respect their evidence, and the actual evidence of the committee has provided further information for us to make our judgments upon, and it would be foolish for us to adopt a position months ago and then stick fast to it in the light of the emerging evidence and the evidence, indeed, a more thorough understanding of what happened in Sweden as well. But I do want to say there is a caution, and police officers are naturally cautious about just what the unintended consequences might be as well.
Well, I think it's a very welcome move, and it shows the benefit of this committee system and the benefit of people listening in to the hearings, and I am certain the committee can give some consideration to allaying your fears, but that I see as a major step forward in the protecting of vulnerable women in Northern Ireland.
If I may just reiterate a point I made earlier on, just to drive this point home. Organised crime is about making money, and it's driven on a supply and demand side. If one of the consequences of this bill, and particularly around the Clause 6, is to have that 85% of men who today visit a brothel, today visit a prostitute, determine that they would not then visit a brothel, that changes the supply and the demand nexus. And organised crime would react to that. So you may have, and it's only on hypothesis, that 85% of people who are today using a brothel or a prostitute, if they determine that they're not going to do that tomorrow for fear of being prosecuted, then that changes the supply and demand nexus, and that would have an impact on organised crime generally.
But that's not an excuse not to do it.
Well,
Pardon me?
It's not an excuse not to do it.
No, it's the opposite.
It's the reason to do it.
Yeah.
It is. I mean,
Yeah, absolutely.
Okay.
No, that's right. I thought I'd made that clear. That's the point that I'm making. If the bill passes and it has that effect, then we'll be the first person to say, then hallelujah, because we're in the business of protecting vulnerable people.
Amen.
It is worth saying that in the Twitter sphere and the internet there is huge insults being thrown at members of this committee and Lord Morrow, because there's a fear amongst the industry that if we go down this line, the Republic might do it and eventually the rest of the UK, that the industry will then react by moving somewhere else. And that's what happened in Sweden. They moved across the border to Denmark. But we have no control outside of Northern Ireland. We have to do what's best for our people. So therefore, they clearly see the writing on the wall as far as this legislation is concerned. They're not sitting there saying this is going to have no impact on prostitution. They are extremely worried. And that's where we all want to get to, is less organised crime and fewer vulnerable women locked in rooms being abused as we speak.
Okay. Mr. Elliott?
Chair, thank you, and thanks very much. Apologies for missing the start of your presentation. Just a couple of questions. If you've dealt with some of this, just please tell me. You did mention that the percentage of prostitutes in Northern Ireland that are trafficked. Can you remind me of that percentage?
No, I wasn't able, and we're not able really to give a percentage. I think the search was quoted there as between 1% and 2%, but as I said today, I could not put a figure in that, Mr. Elliott.
Okay.
I think we would say that probably the prostitution picture in Northern Ireland is more tainted towards the people who have not been trafficked than those who have been trafficked.
Okay. Regarding Clause 8, you did mention that, and you said it would be unwise to introduce automatic immunity prosecution. Do you believe the current legislation that's there is sufficient?
Well, Clause 8 makes it as almost a mandatory immunity. We have seen people in the course of our investigations raise nothing about them being trafficked when they're caught in the middle of the cultivation of cannabis especially, and very, very late in the day suddenly throw in the allegation that they've been trafficked. Now, we're obliged to pursue that as a very proper allegation. Oftentimes we haven't found evidence to support that. This would allow people to claim from the get-go, I have been trafficked, in a range of different criminal investigations. If you're caught driving from Fermanagh to Belfast and you're caught driving with 100 kilograms of cannabis, you could see a circumstance where you would immediately say, I'm being arrested, I'm only doing it because I've been trafficked. Well, if that's the case, it potentially raises a number of barriers to prosecuting people who haven't been trafficked but who've been involved in serious criminality. But is that automatic assumption that they get an immunity would just raise some difficulties? I think those issues of immunity have to be addressed in the round by the prosecutor understanding the totality of the evidence that is presented to them.
Okay. You did touch on your evidence on a little bit today again about the Swedish model, and basically, putting it in my terms, you don't believe it has been effective as it was intended to be, or maybe as some pretended to be. Why do you think that is? Why do you think it may not have been as effective?
Well, I think prostitution in Sweden, and I'm not an expert on that country's legal system or the particular policing problems they face, but it does seem to me that the problem they face with prostitution was a very significant social issue, and that this legislation came after actually a number of decades of consideration about what should be done about prostitution within Sweden. The difficulty then having with that base of a problem is there's money and there's demand, and as Roy has said, organised crime works to gain money against an illicit demand, and therefore then I believe the Swedes had a very difficult problem in terms of the prostitution, the problem they faced, now coupled with human trafficking. And we have first-hand experience of working with the Swedes in respect of human trafficking involving prostitution. We, thankfully, I think, are starting from a different base level in terms of where prostitution is, both in Northern Ireland and hopefully on the island of Ireland. but certainly in Northern Ireland. And we are at an advantage to the Swedish. That may mean that we do not see all the advantages that the Swedes did enjoy, but I think we also then do have a different legal system, and some, obviously, of the operations that the Swedes conduct are precluded to us for legal, because of the law will not allow it.
Okay. Finally, Chair, I think your words were yourself that while the police is still opposed to Clause 6, there is a qualified majority or a qualified support for it. Can you explain that a wee bit further, because it does leave it hanging?
Well, we're not opposed to Clause 6, if I want to paraphrase the chair back to him, but we are not opposed to Clause 6. We have qualified support because just of some of the consequences that may flow, and we've talked about those at some length. Mainly information flow, but more importantly than that is the vulnerability of those who are prostitutes.
Okay. So, just to be clear, your paper you've provided to us is not now accurate?
No, I think what was said is that since the paper was submitted, we've looked at it against not only the evidence that has been heard in this committee, but the additional learning that we've had in the course of investigations, conversations, discussions with professionals, the NGO engagement group that has been set up. There's been a variety of information sources, and it just allows us to think, well, taking an absolute position, maybe not something we want to take at this point. So the paper was presented in good faith. It was presented as our position at that time, but to use the cliche, when you have new information, you have to consider your position.
Okay. Thank you, Chair.
Okay, and I think that's the right way for people to approach this discussion. And indeed, it was a Sinn Féin TD who said he came into this with his eyes maybe a little bit blinkered, but having tested the evidence, examined the issue, he now wholeheartedly supports what they're trying to do in the Republic of Ireland, which is exactly what we're trying to do here in Northern Ireland. So I think that's the responsible way for organisations and individuals to come to this issue, to make sure that they don't have closed minds and that their eyes are open. So I think that's an approach to be commended. Mr. Anderson and then Ms. McCauley.
Thank you, Chair. Thank you, gentlemen, for coming along to the committee today. We've talked about the international crime gangs that's operating not just here but right across Europe, other field. And Mr. Humphrey, some colleagues here, I think Mr. Dixon touched on the fact about the National Crime Agency. And I think it was you, Roy, used the term that when it comes a certain distance with the top operating here, you come up against sort of an invisible barrier. Was that the term you used?
Yeah, it was like an invisible border.
Or invisible border, right? How much of a hamper do you see that in relation to trafficking right across Europe when you come up against that you have to more or less pick up the pieces? Is there a big void there that would be greatly enhanced if we had NCA operating right across?
I think any time that we work with the predecessor of the SOCA, the predecessor to the NCA, if I could describe it, that they would take on international investigations, which in effect had a foothold in Northern Ireland. And so they would take on these big international pieces of work with scope. We would assist, but they would be one of the lead agency, and that's primarily, one of the things that we're good at doing, and the NCA has picked that up as well. What happens now is, as it arises in Northern Ireland, then we have to lift, in effect, the mantle of law enforcement. So that creates a break, a lacuna in the operation. And therefore, then, we have to prioritise the work we were involved in. So it's a resourcing issue. It's not perhaps the most effective way to work operationally, and we are cut off from, in effect, a surge facility. But beyond that, and in longer term, there's still the asset recovery through the civil courts, and that will be a bigger and growing issue as the months go by. But we do have a lot of goodwill with the NCA. We do have information sharing agreements with the NCA, and we understand also, and we have been very much involved in the issues around and the discussions around accountability of the NCA operating in Northern Ireland.
What I'm trying to work out here, how big a void there is here. How much more would it help if NCA was operating right across? Is there such a big void here that if you didn't talk about numbers, or I forget the numbers of traffic into the whole of Ireland?
Yeah.
You know.
Well, we have a finite capacity. If we need additional support, the difficulties of getting mutual aid for that are well documented. We have a capability before the 7th of October to use NCA officers who had the powers to assist us in investigations. From the 7th of October, that was not available to us. So that became something we couldn't rely on, and we had to become self-sufficient. And this isn't just about human trafficking, this is about organised crime or serious crime in its widest remit. It's just simply not there as an asset. And the point we're making is also that Northern Ireland is not isolated from the internationalisation of organised crime. It's here. Organised crime of an international nature is here in Northern Ireland today, and the NCA provide that international reach, and at times that is denied to us, which can only have an impact of making Northern Ireland a more vulnerable place for its citizens and a more lucrative place for organised criminals.
Yeah, I think what we're saying today, but if we had NCA operating right across, it would be so much more helpful resource-wise and everything else.
If you take just one example, the amount of money that can be made in human trafficking and in prostitution, drugs activity or other organised crime activity is significant. We need to prosecute people. We need to have a criminal conviction before those assets can be taken off them if they're within Northern Ireland. If we can bring that higher standard of proof, which is the criminal standard of proof, we don't have the option to use the civil standard of proof to take assets off them, and therefore people that have been involved in the most egregious of criminality can hold on to assets simply because we can't find the higher evidential standards of proof. So you could find a situation where Northern Ireland becomes a place where criminal assets are left untouched simply because the ability to take it off it is not there in statute, or the agency who's empowered to do so.
That's worrying, and that could happen. So I think what I'm trying to say here today, and I think others would say, is NCA would be a tool to work right across and would effectively control this down. Okay, thank you very much.
Thank you. Ms McCorley.
Very much, Chair, and thanks for letting me in again. There's just 2 points. We've been a long time with this discussion today, but it's been all very useful, and reference was made to legislation in France. Now, my understanding is that it was a comprehensive piece of legislation, and the difference here is that in the human trafficking bill there's one clause which deals with prostitution, and I think, given the reservations that you've expressed, and I have concerns about the impacts on people who will be affected by it and the unknown consequences, because we don't really know. I think there's a good argument that we just need to have separate legislation on prostitution and do it in a comprehensive way rather than in a single clause way which just deals with it, and leaves it hanging and doesn't deal with other aspects and outcomes and consequences. So I'll be wondering what you might think about that. The other point is there's been reference to how the Clause 6 will criminalise the buyer and decriminalise the seller, and that has been said. But I'm not sure that that's true. I'm not sure that there is decriminalising of the seller. I mean, could you make that clear?
I don't think we've used the expression the decriminalisation of the seller. At this point in time, a woman selling herself for sexual purposes does not commit a criminal offence unless she's in a brothel. This legislation doesn't change that. What it does do is change the buying of that from the other party. So it criminalises one element of it. So the seller commits no offence, the buyer does
Yes,
come
and
an
I mean,
offence.
that's how I read it, but if it's just, it has been described in a way which sounds like it's making life a bit better for the seller, but it actually doesn't change anything.
No, I don't think it, well, legally it doesn't change
Yeah,
the situation of the person, in the case of a male-female, it doesn't change the situation of a woman who is who's selling herself for sexual services. Legally it doesn't change that person. The buyer becomes the one who's committed the criminal offence.
Okay. And the other
So
point?
in respect of the wider piece, well, you know, we're a law enforcement agency. We give our views. We're invited here. We're grateful for the opportunity. We give our views as to how we think legislation may impact. I think this legislation raises a number of possible positives, possible negatives. We don't know because it's such a difficult issue, as has been mentioned to my left here. But ultimately, if the legislation provides an opportunity that it reduces the harm to vulnerable people, if it reduces the demand for sexual services and has an impact on organised crime group activity, if it reduces the impact on human trafficking in Northern Ireland, then all that's for the good. If it has the reverse effect, then clearly that hasn't worked. So, I mean, it's unfortunately, we'll not legislate. That's a matter for yourselves.
Thank you.
Okay.
Thanks.
Lastly, Mr. McCartney.
Thank you very much, Chair. Thank you very much for your presentation. I suppose on a lighter note, I was just reading that paragraph where the Lord Chief Justice says we were acting outside your powers as you were walking in the door, so probably had sent you very early. That's maybe for an hour day, as the saying goes like that. But just in relation to, I mean, and it's interesting to follow your own commentary, you know, and as the Chair said, no, people should be, you know, led by evidence. But a number of years ago, Assistant Chief Constable Will Kerr was in front of the Justice Committee, and I think at the time, you know, he made, to me, was a very sort of forthright and honest sort of assertion where he said there would be no police service in the world that would refuse any power. No, but it's saying what you do with it. And the particular piece of legislation which we were discussing at the time, I actually think it was around alcohol on buses, and I think he made the point that a good power to have, but whether you ever use it or not is something else. Which, so you can see that type of debate even around Clause 6. You can see why a power have it, whether we use it or not.
It's like a fire extinguisher.
That type of, and that's what we have to ensure that we don't do. You know, that we just don't legislate because we think it's a good thing to do, but it has no consequence. So we don't tackle the problem which we're trying to. So have you any view, just anything else?
I think just what we've said about what we would see as the difficulties perhaps in gaining this evidence and how we would see it in the organised crime group arena, so that we could use a full menu of police tactics to get evidence. But if law was passed, the legislation was passed, we would respect it, and we respect it in the manner in which it was passed as well, i.e. what the actual purpose, intent was of it, and to try and reduce the demand for prostitution. But as we've outlined at some length, it's not to say then there's going to be a whole set of operations around all prostitution. That would not happen. We would have to prioritise and focus where we saw organised crime, primarily because of the serious harm which is always involved with organised crime groups.
No, because, I mean, and it's always interesting because, no, as we all do it when we use statistics, they either prove or disprove something, and sometimes it can be used very liberally, right? Because I mean, we're told that no one knows the extent of the nature of prostitution in the north. So nobody knows the precise number. So when you hear people talking about percentages of what is an imprecise number, you know, it's just with that in mind. But it is a crime at present for a person to pay for sex to a coerced person.
Yes, and there's an important change in terms of that not becoming statute barred.
Yeah. And Superintendent Marshall, when he was speaking and allowing him to use percentages, he said that, in his opinion, only 2% were doing it by choice. So that's 98% not doing it by choice. So it's a form of coercion.
But the coercion could as much be in the dire straits that they find themselves in socially, in terms of deprivation or drug addiction or mental health, whatever. It may not be human trafficking type coercion.
No, I accept that. I accept that. But I'm just making the point that, you know, in terms of deterrent,
Yeah.
you know, a person who enters into that arrangement doesn't know if they're doing it with a coerced person or a trafficked person.
No.
So the deterrent fact of it. How many people have been convicted of paying for sex to a coerced or trafficked person in the last year?
No. On the basis of the legislation requires that charge or summons to be brought within 6 months of the sexual engagement taking place, or the purchasing to take place. And in the investigations that we have had, unfortunately, and we have to take our own responsibility for the fact that we focused on the rescue of the victims and the targeting, the prosecution of the organised crime groups, and it was a very deliberate action on our part to target as a second wave those men who hadn't been involved in buying the sexual service, and it was an error on our part that actually that was statute barred. So the answer at this point, Mr. McCartney, is zero.
So, and then if this law, no, if this was passed, then we've heard that in Sweden there's a heavy reliance on wiretapping, as it's called, right?
Yes.
But,
We're precluded from that.
you can't do that.
No.
So,
We're precluded even from talking about it, really. So, legislation. So it's not going to be an evidential avenue for us.
and perhaps one of the interesting things, because I've never heard it before, and perhaps would your officers have submitted a report as their experiences to the when they were in Sweden?
How do you mean a report?
No, maybe a published report. When they came back, they say, "No, here's our views."
No, it was
shared.
No, it was in the context of a live operation.
Right.
So it was the operational learning from two law enforcement agencies that have different law enforcement elements working together for a single purpose. So it was that, you know, we do this, they do that, they can do this, we can't do that, we can do this, and it was in that environment. There's been no report submitted on that basis. There is a prosecution report, which will be with the Public Prosecution Service, but that's not the type of report I imagine you're referring to.
Would it be something that you feel would be helpful for this committee to reviews?
Well, no, because its purpose is to consider the prosecution of people who
I'm talking about perhaps asking the officers that were in Sweden, in light of this discussion, you know, maybe a bad idea to put our thoughts on paper so we can share, because that's people who in the future could be tasked to pursue this, and they have had experience of the.
I trust I haven't misrepresented their experiences.
No, I wouldn't suggest you have, but I mean sometimes, as you've said, it's you know, it's. Yeah. I'm not doubting the accuracy, but in terms of formulating an evidence-based report, that might be better we had it in writing from.
I'm slightly worried around that, because I think what you're talking about is, forgive the expression, but you've got two cops having a conversation, one Swedish, one from Northern Ireland, and that's not to say that they're inaccurate or they're making anything up, but it's two police officers having a conversation like this, and converting that into a report that comes to this committee, I think, is probably not what the conversation was intended to be.
Okay. That's fine.
Very finally, because you've been very generous with your time, but I just want to get a bit more detail on the evidential requirement before you can use your covert. The offence for trafficking is obviously beyond 3 years. You know, people who are involved in trafficking can get a conviction. So does that not meet your threshold?
It does.
So, but if it was trafficking on the basis of someone's sexual servitude, you couldn't.
You can, because the trafficking is the trafficking for the purpose of sexual exploitation reaches that threshold.
So if you
prostitution that doesn't have trafficking, prostitution and the 1 year threshold that is proposed in this bill wouldn't reach that threshold. Or for some of the covert, the high-end covert activities.
It's how you can identify. Obviously, you'll know information comes in. There's a brothel here. Is that just, and I hate using the words consensual prostitutes because I really question mark it, but, or that's human trafficking victims, we can use covert methods.
Well, what you'd want to establish is that the activity of an organised crime group, or is that activity outside of an organised crime group? And I'll not use the expression consensual. Is it within an organised crime group, and therefore then other elements of serious harm will be present, and so either be trafficking, coercion, violence, whatever it might be, or is it outside an organised crime group?
Okay, but you couldn't, if you identified a brothel, victims of human trafficking are involved, you say, right, this meets the test for us to use covert. If that didn't identify a human trafficking victim, and someone came in and used a prostitute that wasn't of a human trafficking nature, and the offence was only going to be 1 year, you couldn't prosecute them on the basis of the covert evidence.
We wouldn't have the evidence from surveillance. There may be, I understand in Sweden some prostitutes have given witness evidence, and they understand as well that suspects are willing to make admissions to this and have the matter dealt quickly through the courts, but we would have to present a case which was complete to the Public Prosecution Service in terms of the offence alleged. Not to say it couldn't happen, but I think again our emphasis and our priority and how we would use our resources is always going to be around organised crime groups and serious harm.
And just in the scenario that you've painted, Mr. Chairman, if we had information that a particular premise was being used today for prostitution, where people were being held as traffic victims, we wouldn't be seeking to use covert means as a first step. We would be looking to do a fairly rapid intervention in order to protect and to rescue the victims. So using covert, which sometimes can be a slower burn, wouldn't necessarily be our first start. We would seek to use the powers that we would have to enter and to rescue victims first of all.
Okay. That's worth emphasising, because just even in respect of feedback that you received from Anna, like our priorities are in the first place public safety, safety of these individuals. The criminal justice strategy is third or fourth. You know, really, the purpose of our interventions are to prevent further harm and save people from further abuse.
But would your covert, if you ever had it, and the videoing of someone walking in, as it showed us in Sweden, they walked in, 15 minutes later they walked out, that was pretty much enough, you know, to prosecute. Would that be even admissible in a proceedings here if you had that, to charge someone purely on you've broke the law in respect to clause 6 and here's the covert information to prove it?
Well, if that was the height of your case, I think you'd be well short of the proofs that PPS would require, because there is, you know, two elements. There's an exchange in terms of purchase, and then there's an exchange in terms of sexual service provided. Yeah. Those would be the two elements. Just going in and, you know, going in and out of premises would not be sufficient.
Maybe misrepresenting, because they did say that they then go in and they get a witness statement from the individual, and that's usually enough to...
And they use their wiretap evidence as well to show the intent of the person.
Yeah.
But we're precluded from doing that.
Raymond had a last point.
It's just in relation to how many people would you have rescued from trafficking?
Bear with me 1 second, I'll give you the... Since 2009, the police service have conducted, and it's been my own branch has conducted 12 operations, 12 proactive operations. Outside of that, we have rescued 18 potential victims of human trafficking in those proactive operations, conducted 75 searches and arrested 41 people.
And would that all be in terms of sexual exploitation, or would it be across the range of human trafficking?
Those are almost, in fact, they are exclusively for the purposes of sexual exploitation. Now, the figures for the number of victims that have been rescued is a greater number, but those are the proactive intelligence-led operations that the PSNI have led. So that's 12 operations, 41 arrests, 75 searches, and 18 victims of human trafficking.
Okay, thank you.
Well, Mr. Harrison, Mr. McCrum, can I thank you both for coming to the committee? I know it's been a long time going over it, but your evidence has been very helpful, so thank you.
Thank you very much.
Thank you.
Thank you. Okay, members, we will keep moving on and go to the next item, which is the proposed consultation on extending the draft mental capacity bill to the criminal justice system in Northern Ireland. Proposed consultation on the draft bill will contain health provisions of the bill criminal justice policy proposals and a Department of Health, Social Service, Public Safety paper with the Department of Justice input, which detail proposals in respect of legislation for under 16. The relevant pages are 109 to 214 of your meeting folder. So let me welcome Mr. Gareth Johnson, Deputy Director of Criminal Justice Policy and Legislation Division, Tom Hare, Head of Criminal Law Branch, and Michael Kelly, Criminal Justice Policy and Legislative Division within the Department of Justice, to the meeting. So you're all very welcome to the committee. And at this point I'm going to hand over to Mr. Johnson, who's going to take us through the briefing paper.
Thank you, Chairman, for the welcome and for affording us the opportunity to provide an update on the new Mental Capacity Bill from a criminal justice perspective and to explain the consultation exercise on the bill's contents, which we plan to launch jointly with DHS-SPS. You'll recall, Chairman, that when we met you on this in January last year, we discussed the report on responses to the public consultation exercise we'd undertaken in the summer of 2012. That was where we set out our initial proposals, and discussion with stakeholders since then has proved extremely helpful. Given that we've been working through a number of issues and there have been pretty significant developments in our thinking in some areas, we believe it's important to give stakeholders a further opportunity to comment on the proposals before they come to the Assembly as a bill. And that consultation will be in conjunction with DHS-SPS, who will be consulting on the draft Mental Capacity Bill itself. The proposals before you today represent a joint and agreed approach between the two departments. The proposed bill represents a very new approach, not just for Northern Ireland. The fusion of mental health and mental capacity law hasn't been attempted in any other jurisdiction, and its extension to those subject to the criminal justice system is also unique. Now, that has meant that all of this has been a very complex exercise for us in policy terms, and it's been helpful for us to be able to see what has emerged on the health side before trying to map that onto the criminal justice system. I have to say we've greatly benefited from a close working relationship with DHS-SPS colleagues in that regard. As you'll be aware, this work emanates from the Bamford Review into Mental Health and Learning Disability Services. That review recommended a single legislative framework for the reform of mental health law in Northern Ireland. It advocated new mental capacity legislation for the jurisdiction, and crucially, that it should apply to people who are subject to the criminal justice system. This was something that the Justice Minister and the Health Minister signed up to, and was an approach that was subsequently endorsed by the Executive. The draft bill will therefore introduce a new legislative framework governing all decision-making in relation to the care, the treatment, whether it's for a physical or a mental illness, and the personal welfare, including welfare in financial matters, of persons aged 16 or over who lack capacity to make a specific decision for themselves. The new approach will provide significant additional safeguards for such persons that go beyond those currently provided for, and in doing so it will replace the current Mental Health Northern Ireland Order 1986. This is central to the Bamford Report's vision of reducing the stigmatising effect of having separate mental health legislation. The bill will be based on a number of key principles. They include a fundamental principle of the existing common law that people over 16 have the right to make their own decisions unless there's proof that they lack the capacity to do so. Significantly, it will also place an emphasis on helping and supporting people to exercise their capacity to make their own decisions where they can, rather than stepping in with substitute decision-making at an early stage. If, however, a person when all those supports have been put in place, still lacks capacity to make a specific decision regarding their care or welfare or treatment, the bill will require safeguards to be put in place before an intervention in any of those areas is carried out. And in particular, any intervention in the life of a person lacking capacity must be in that person's best interests. Now, these safeguards are designed to protect and support the person lacking capacity, and the more serious the intervention proposed in that person's life, the greater the safeguards that will need to be put in place for that person. The real challenge for us, Chairman, has been to combine these principles with the statutory criminal justice powers which are exercised by the police, the courts and the department itself to divert persons out of the criminal justice system and into the health system. I mentioned engagement with stakeholders, and those from the mental health and disability sectors, as well as the various criminal justice agencies have been involved. And this engagement has ranged from formal meetings of our departmental reference group and our steering group, to meetings of the DHS-SPS reference group, the Interdepartmental Project Board, and numerous workshop-type meetings with a range of stakeholders over the course of the last year or so. Our objective throughout has been to try and ensure a consistency in approach between the health and the criminal justice systems, while still keeping our vital focus on public protection and on the duty of care that we have to vulnerable people in the justice system. We have adopted the view, which is implicit in the recommendations of the Bamford Group, that a capacity-based approach can and should be taken in the criminal justice system, and that our stance should be one of no compulsory treatment for those with a capacity to refuse. We believe that that can be adopted with no detrimental impact to public protection or to the duty of care to those within the system. In other words, the mere fact that someone is in the justice system wouldn't mean a lesser standard in the approach to their health and welfare. The Health Service now delivers health care within the criminal justice system, and it seems to us appropriate that it should do so in accordance with the same standards and procedures that it would apply generally within the community. And so the key phases of the criminal justice system where statutory powers are currently exercised under the 1986 order will be brought into line with the capacity approach. There are three categories of those. First of all, police powers to remove persons from a public place to a place of safety. Secondly, court powers to impose healthcare disposals at remand and sentencing or following a finding of unfitness to plead. And thirdly, the powers by which the department can transfer prisoners for inpatient treatment in a hospital. Where an offender has capacity to refuse an intervention in relation to his care, treatment or personal welfare, that decision will be respected. Where that person doesn't have capacity, lacks capacity, then decisions will be made in accordance with the Bill's procedures, principles and safeguards. And maybe I could explain that by way of an example. Where a court is considering remanding a person for inpatient treatment or making an order for such treatment, the court will determine by way of professional reports and advice that the treatment is required and is available. That's step one. Step two is that on the basis of those reports, it will also consider the capacity of the person to make a decision about accepting that treatment. If the person has capacity, the order will only be made if he would consent to the treatment. If the person lacks capacity in relation to the treatment, the order will only be made if the treatment is in their best interests. And if they lack capacity, the court will also consider any risk of harm to the person and to the public if treatment were not to be given. If detention for treatment is required, the court will then have been satisfied that inpatient delivery in a hospital is the most suitable way of providing it. It might, in the first instance, consider and prioritise release on bail with conditions, as is the case in the criminal law more generally. I would want to stress, though, that the model we're developing will see the courts, the police and the prison service retaining their overarching statutory powers around detention as distinct from treatment. Detention for the offence may be imposed regardless of capacity, but treatment will be based on the capacity principles. The project chairman has also examined the law on fitness to plead. We commissioned the Northern Ireland Law Commission to examine the current test for fitness. It found that the elements of a mental capacity approach could enhance the test, and the department therefore proposes to incorporate this revised test within the capacity framework. I said earlier that that how we marry the capacity approach with the public protection and the other responsibilities of the justice system has been a key issue for us. There could be a very rare situation where a person has been unfit to plead, is found by a court to have committed the act in question, poses a high risk and requires treatment in hospital, but yet, by the time the decision comes around, has capacity to refuse such treatment. Now, because they are unfit to plead, prison would not be available to a court, nor would the treatment-based options, yet potentially serious risk would remain, and in effect that person would be in something of a legislative vacuum. To cater for that potential gap, the department is considering the concept of a protection order to allow such a person to be detained for protection rather than for treatment. In such, albeit potentially rare circumstances, the court would be able to impose a protection order requiring the person to be detained in a care-based environment until the level of dangerousness had reduced. The protection order would be of limited but renewable duration. The department is considering an initial 6 months with provision to extend the order thereafter. The department recognises the difficulties involved and the interests that must be balanced in respect of such a disposal, and it's an area where we are particularly seeking views through the consultation exercise. If I could just almost finally, Chairman, say something about under-16s. We'd also welcome views on the approach to under-16s. DHS SPS take the view with which we agree that the bill can't be applied to under-16s. Fundamental to the bill is the presumption of capacity, and to apply that to young people would undermine the role of parents and have a significant impact on the current legal framework, which is designed to protect children and to govern decision-making in relation to them. We acknowledge, however, that the current legal framework is complex and that there's also a need to give further consideration to the emerging capacity of children. And the Department of Health has therefore proposed that a separate project should be undertaken to consider this in the context of a review of the Children Order in the next Assembly mandate. Pending that review, it's proposed that the Mental Health Order will continue to apply to those aged under 16 who require detention for assessment or for treatment of mental disorder. Now, in the criminal justice system, these powers are very rarely used. In addition to the protections that are in the 86 order as it stands, it's proposed to make amendments to it through the draft bill to insert additional protections for those children to whom it may apply, and in parallel with our consultation, the DHS SPS would be consulting on what those protections should be. That leads me on to equality issues more generally, and we recognise the overarching impact of under-16s not being included in the current mental capacity framework as a whole. We've screened the proposals accordingly, and we have screened them in as requiring a full equality impact assessment on the grounds of age. That equality impact assessment has been prepared by the Department on its criminal justice proposals and will be published with the consultation, and I understand there is a copy in your packs. The EQIA recognises the impact regarding under-16s, but also sets out the mitigating effect of the proposed additional safeguards being brought into the 86 order and the more fundamental and wide-ranging review of the Children Order that will include consideration of the issue of emerging capacity. In terms of next steps, subject to the committee's approval, the criminal justice consultation proposals will form a part of a joint consultation pack, which will also include DHSPS's consultation on the civil bill and the proposals, as I've mentioned, in relation to under-16s. As the consultation is a cross-cutting issue, it will go to the executive shortly. It's envisaged that a 12-week consultation will commence in March, and this would allow for the combining of the civil and criminal justice parts of the bill in the autumn, with a view to introduction into the Assembly in January 2015, and that would allow the bill to pass before the end of the current mandate. Chairman, we'd be aiming to report back to you following our analysis of consultation responses, and before moving forward to introduction. It may well be that that's an opportune point for the Assembly to consider putting into place the ad hoc committee arrangements for this bill, which I know were discussed previously by both committees. Thank you, Chairman, for allowing me to set out our proposals, and apologies that at this hour it has been at some length, but it is a very complex piece of legislation.
No, and apologies that we were so long previously and we're a little bit behind our schedule, but I understand why it's taken a bit of time to get through this. Mr. McCartney?
Thank you very much, Chair. Just a number of things. I mean, the detail is obviously, we'll go back to the detail, is more about the process. The idea of two consultations running alongside, where one consultation impacts on the other, how do we resolve that?
Well, we've been working very closely with Health on the two. I think the way that they will be presented is in the one pack and kind of as different chapters of the one pack. Certainly, we've taken very careful account, and we've been shared all the drafts that Health have been producing. So while there are two departments involved, and while we thought it was sensible to identify the health proposals and the criminal justice proposals, in practice, we've been working very closely together.
And if there's say like a public, meeting aspect of this, will it be joint officials?
Those will be done jointly, and in fact, we're just in the process of planning a joint consultation plan, which will include public meetings.
That's fine. And in terms of, you're saying that there's going to be a separate process in relation to under-16s. Is that getting taken forward by one department or both departments?
Both departments will again be involved. It'll be led by the DHSPS, but we're going to be inputting to that process too in terms of young people in the justice system.
If coming out of the consultation process, the initial consultation process, there's aspects which impacts on the Children's Order. We're not doing that the next mandate.
Well, there are things that we can do in the current bill around strengthening the protections for young people, and we can put those insert those into the 86 order. In terms of the wider issues around emergent capacity in children, those would be the focus of the bigger project next mandate.
Okay, and could you just give me your sort of timeline proposal for dealing with the under-16s?
The bill that comes to the Assembly in January 2015 will contain additional safeguards which that bill will insert into the 86 order. So that'll be dealt with as part of this process. Then in the new mandate from 2016, we would envisage the wider review of the children order taking place.
Part of the consultation pack actually will have an under-16s chapter in it that both departments have contributed to.
So like there will be provision in the bill to make sure that the amendments are in place if required. That's fine. And in terms of the wider process, in particular, when it relates to the under-16s, the quality impact assessment will be built into all aspects of this.
The Equality Impact Assessment has, Health have done an assessment as well as ourselves. Yeah. So both assessments have taken account of under-16s and have recognised mitigating factors that need to be put into place in the meantime.
Okay. Thank you.
Mr. Wells?
You're absolutely confident of January 2015?
Well, certainly a great deal of progress has been made. We have sent instructions to Legislative Council. We'll be following those up with instructions in further areas, and the timetable has been agreed by the two departments.
This is the 5th date that's been given. The 5th date. For introduction, the 5th different date that you've given us for introduction.
Yeah, indeed, yes. But actually, it's a date which is closer. And I think at one stage there was an indication that there might be an introduction later into 2015, which would have been difficult in terms of getting through all the assembly stages. So we have looked again at this and we've been able to move it forward.
I'll put the same proposition to your colleague, your equivalent in the Department of Health, because I put in both committees. I said, will you give me £500, my favourite charity, if you don't meet that deadline?
I wish I could remember the response that Sean gave, because it was a lot cleverer than I'm going to give. But suffice to say, we have strengthened our resources on this within the department, and we're working very hard on it.
I did say to him, the charity I had in mind was the Jim Wells Benevolent Fund, but he wasn't so happy with that one. I'm being serious about it. I mean, we if you miss this one, this is a very complex piece of legislation, which has to bring together an ad hoc committee made up of members from both committees. I know who's going to be unlucky enough to sit on it. I can see that coming my way. But which means we'll sit on effectively 3 committees until this legislation's through. And having done the same thing on social development, we know what it's like. Yes. If you don't deliver in January, this Assembly's in big trouble with this legislation, and it has to be got through by the end of this mandate, or else we have to pick up the threads in the following mandate.
I mean, that message has certainly been understood. We have, in fact, between the two departments, just appointed a programme manager for this, whose job is to keep us all right in terms of timescales and to make sure that things happen when they need to.
And is that person known? Has he been announced? Or she?
Yes, he, yes. There's
Andrew Dawson.
Andrew Dawson.
Right, so he's taking it forward.
Yes.
Well, I just hope it happens. I really do, because I've had so many false dawns in this. It's a desperately important piece of legislation, particularly on the health side, where the vast majority of the expenditure will be. And, we'd feel terribly let down if it didn't happen. To put it mildly, and the present legislation, dates from '86 is terribly out of date, and this brings protection to a lot of very vulnerable people, and we support the principle of what you're trying to do. It's just I would like to see it happen before I retire. That's all I have to ask, Mr. Chairman.
Okay, thank you. Or you're retired. Any other members? Well, we look forward to more progress. Thank you very much.
Thank you, Chairman.
Move on to the next item. In January, the committee considered and agreed 8 action plans brought forward by the department to deliver various strands of the community safety strategy, which was launched by the Minister of Justice in July 2012. The department also undertook to provide a written report on progress to deliver the plans on an annual basis to the committee. The first report is now available for consideration. The report provides information on work plan for 13-14 year, with what has been delivered and what will be taken forward in 14-15. The report also highlights how the PCSPs have contributed to delivery of action plans at a local level and provides information on a range of examples of local initiatives and interventions. So it's whether members have any more information or they require, or if you're content to note the briefing that's been provided. And a related point then, the next item deals with a review of the code of practice for appointment of independent members of the policing and community safety partnerships. The department had scheduled a written briefing paper for consideration by the committee at today's meeting on a draft consultation on a review of the code of practice for the appointment of independent members. The department indicated late on Monday that it's not in a position to provide this paper for the meeting today. The ministers requested some additional consideration of issues contained within it, and then we'll get a briefing at a future point. Noted item 9 is Committee for Justice EU Priorities and Report on EU work undertaken. Pages 15 to 35 of your table pack. The Committee for OFM DFM has written providing a template for each committee to document their EU priorities and proposed actions for 2014 and the work it has undertaken on EU issues during 2013. The Assembly Research and Information Service provided a paper setting out priority actions in the 2014 European Commission work programme. There are no substantive justice and home affairs elements due to the Stockholm 5-year Justice Home Affairs programme coming to an end in 2014. The next programme is from 2015 to 19, which is likely to be discussed in June. So there's a draft response on the committee's EU priorities for 2014 that's been prepared, and if members are content with it, we will provide that response. Okay. Correspondence, 5 items of correspondence and 1 item in the tabled pack, and I'll draw attention to some of them. Item 5 is a response from the GMB Union, clarifying the nature of its connection with the International Union of Sex Workers. So I think it was Mr. Dixon that maybe sought that out information, so it's there for members to note.
In case you want to join. The GMB, that is.
Item 1 is of the table pack is a report by the NCA on the United Kingdom for the Trafficking Centre National Referral Mechanism Statistics. A copy of that report and correspondence from the department was emailed to members on Tuesday. So if there's any comments around correspondence table, then we'll agree to action as outlined. Agreed. Chairman's business. I and the Deputy Chair have received an invitation from the Policing Board to attend a Confidence in Policing conference on the 25th and 26th of March at Titanic, Belfast. So I'm not sure if I can attend at this point. Item 2 is an invitation from Community Restorative Justice to its annual general meeting. An invite has come in for Friday, 14th March for that meeting, and I am unable to attend it. Item 3, Chairman's business. Training is available to all members and party staff on the use of OneNote, which is a software package from Microsoft that can be used for note-taking and collecting, organising and sharing information, which would be helpful for the electronic committee packs. So that training will be available. So if anyone wants to avail of it, or their staff, it's between 12 noon and 2 p.m. on Wednesday the 26th of February. And it's also on Thursday the 13th of March. So there's 2 days, so the clerk can advise members if anyone's interested.
That's the day we have that thing. Next week. Come back in.
Any other business?
Chair, just one item, and it's more because I didn't get reading these letters from the Lord Chief Justice because I hadn't got my computer up with me. In terms of how are we going to take us forward, are we going to do a meeting, or are we waiting on the legal advice?
We're going to get the legal advice as to how we can respond.
And can one of the questions be, you know, who would be responsible for guiding the committee if we stray out of our powers? Mm-hmm. No, who should step in? No, because no one has advised us that we're outside our powers. So that would be just an interesting if there's someone in the the assembly operation task of saying to a committee, you have strayed here.
Yeah.
Nobody has advised us of that, so it'd just be interesting to feed in the information.
Yeah, well, we can ask that as well. Okay, no other business. And then our next meeting's Thursday, the 27th of February in this room. Thank you.